Good morning and welcome to this session of the live virtual coaching classes of the Institute of Chartered Accountants of India conducted by the Board of Studies. Last week, we began the topic on Negotiable Instruments Act. Negotiable Instruments Act. I told you a lot about the three types of negotiable instruments. We spoke about the promissory note, the bill of exchange, and the check. We defined them. We understood basically what they are, and I think we also looked at the difference between a promissory note and a check. A promissory note and a bill of exchange. A check is basically a bill of exchange, except that, as you know, that a bill of exchange has three parties: the drawer, the drawee, who is the acceptor, and the payee, and subsequent endorsees. So there are three basic parties here. Whereas in a promissory note, you have only two parties, right? The maker, the guy who says, I owe you, I pay you, he gives the unconditional undertaking, right? That is the promissory note. The other guy is, of course, the guy who's owed the money, the payee. Two parties. Whereas in a bill of exchange, there are three parties. It's a basic difference. In the case of a check, what happens is the drawee is invariably a banker. So the drawer is you or me. Whoever has a bank account, we got a checkbook, then the check is an unconditional order. A check is an unconditional order. It's a bill of exchange. An unconditional order directing a specific banker to pay a certain sum of money. That's the only difference. Normal bill of exchange can be A, B, anybody. Whereas in a check, anybody, drawee is always a banker. That's all you have to remember. Otherwise, everything applicable to a bill of exchange applies to a check also, with certain additional points for a check. So we saw all that. Now we are going to move on to advanced level of understanding of negotiable instruments. Now, because I have no other option, I'm going to talk about this topic at this stage, because once we cover it, we'll go. But there are some words that I'm using here that are not defined. I will be doing it very shortly, so don't get worried and start asking me. And also give me 1 minute to sort of your queries and all that. I've not yet opened the query pad. Let me do that quickly so that in case you want to ask me questions, you can, right? Just give me 1 minute. Just give me 1 minute. Okay, we got some more people coming in. Good, but I don't see see my regulars here. For example, I don't see Pooja here. I mean, she's not Pooja is there. Sorry, Pooja is there. Okay, so welcome all of you, and look forward to a good interaction today. Put up your questions whenever you want. Good morning to all of you. And so we are going to talk about certain types of instruments. See, the word instrument is a general term. Anything that communicates a right, okay, anything that gives me a right and somebody else a duty is an instrument. So even an agreement is an instrument. Interpretation of statutes, we define the word instrument. So see, an instrument should be in writing. You can't have a oral instrument. I can't agree, but how do you prove it? That's the point. Suppose I promise to pay you 100 rupees, say, day after tomorrow. It's only a promise orally made. What is the proof? That's why we need to put it in writing, by which you get the right to receive 100 rupees and I have the obligation to pay you 100 rupees. That's an instrument. Okay? Okay, what is an inchoate instrument? It's not inchoate, it's inchoate. The CH is pronounced ka. Inchoate instrument is an instrument that is incomplete in certain respects. Simple example, blank check. Inchoate instrument. Somewhere there is an incompletion. It's not complete. Worst case, I just signed the check. Don't put the payee's name, don't put the date, and don't put the amount also. Ultimate blank check. Don't do that. Never ever give a blank check to somebody, because it's always hanging on the red and you don't know what the balance will be in your bank. So never give a blank check. Okay, a blank check is dangerous, and a blank check is an inchoate instrument. the person signing and delivering the inchoate instrument is liable both to a holder and a holder in due course. Now, these two words are very important. I have not defined them. I'm going to define them. I mean, I'm going to take you through the definition a little later. So don't get worried and ask who is a holder, who is a holder. Simple example. For example, I sign a blank check. Okay? I sign a blank check. I owe you 5,000 rupees. Okay? With some interest possibly. And you tell me, sir, you give, I don't know exact, or I'll give a better example. I got a life insurance policy. I've got an insurance agent who comes to me and says, sir, your policy is about 50,000 rupees. But this way, that way, I really don't know what the amount is, the premium. But I don't know exact amount of premium because some bonus is getting adjusted. So you give me a blank check and I will fill up the amount and I'll give it. So I trust that fellow and I give the check to him. Think about it. Now that check does not mention the amount. It's got my sign on it. It's got Life Insurance Corporation of India, so I am pretty safe. Nobody else can take that money, right? Okay, maybe I've given a wrong example. Assuming that it's a blank check without the payee's name also, without the amount also, date of nothing, just sign and give. Okay? I've not put Life Insurance Corporation also. Now I given to him. Which is stupid. I shouldn't have done that. I did it. Now, the guy takes the check. He's also sincere. He's not trying to cheat me. He's not here to cheat me. He's a good man. So the insurance agent takes the check from me. Now he is a holder. Got it? He's a holder. Because he's got an instrument which is incomplete. Okay. Now what happens is he puts it somewhere in his office and one of his employees is a fraud. Fellow, what he does, he takes the check, fills his name in it, puts some amount and presents it to the bank. My bank also will pay because they see my signature, no problem, they pay. So a paying banker who pays, you cannot hold him responsible because he paid. Because I am the drawer, I've signed there. Amount is the net, it's okay. He can't go beyond that, he can't keep doing an investigation. So he paid. Right? Now, that fellow is a holder, I am a holder, but he is not a holder in due course. Because a holder in due course gets it for good consideration. Whereas the guy who picked up the blank check without my knowledge is not a holder in due course. But everybody who is a bearer of the instrument or an endorsee or a payee is a holder. Okay, now comes the point. If it's an inchoate instrument, the holder of such an instrument cannot recover the amount in excess of the amount intended to be paid by the signer. Be careful. So who is the holder? Technically, it's the Life Insurance Corporation. Okay, and I owe them the premium, nothing more than that. And they can only recover that. But a holder in due course can recover any amount of such instrument. Forget a check, look at a bill of exchange. Now a bill of exchange, if it's in blank, it's also inchoate. Payee's name not mentioned. Amount not mentioned. That's the most dangerous blank check, where the amount is not mentioned. The amount is not mentioned and now Mr. A is the holder, payee. I drew the bill on somebody, they accepted it. I got the document instrument back and I then gave it to Mr. A. A is a holder and a holder in due course. Because I owe him money, I gave him. Now he is holding it blank. Amount not filled up. Right? Now, somebody steals it from him, same example. Okay, but they can fill up. It's not a holder in due course. Suppose Mr. A gives it to B for genuine debt, for which B has given consideration in terms of supply of goods or whatever. So B gets it blank. Now B can recover any amount on such instrument. Provided in India, as I told you, stamping of bills of exchange is a state subject. It's a central subject. See, as per the Constitution, Indian Constitution, both the central government and the state government have the right to make law. Okay? Make laws. They can make laws. Both central government can make laws. Now the Constitution clearly gives three lists. The union list, the state list, and the joint list or the concurrent list. So stamping or affixation of stamp on documents is a concurrent list. Both central can also pass a law, state can also pass a law, for your information. So how much stamp to be affixed on a document? Law can be passed both by state and central. Now, as per their understanding, they are divided and they've said Central can pass laws on stamping of bill of exchange, negotiable instruments like that. Only state can pass a law on deeds and all that. So when you're registering a sale deed, you will go under the Tamil Nadu, so Tamil Nadu Stamp Act. But if you are in Maharashtra, the Maharashtra Stamp Act or whatever, state law. But for bill of exchange, it is a central law, right? Whatever it is. It will be based on the value of the instrument, ad valorem. Ad valorem. I'm sure you saw the word ad valorem when you studied charges. For belated registration of a charge beyond 60 days from the date of the creation, you pay ad valorem fine. Ad valorem, which is linked to the value. Ad valorem or whatever is linked to the value. Whatever. So now for example, if that bill of exchange is stamped, I can go up to the maximum value for which the stamp is to be affixed. For example, not real, don't verify in Google and ask me. It may be different. Let us say for up to 10,000 rupees, the stamp is to be 50 rupees. Beyond 10,000, 100 rupees. So 100 rupees stamp is put, then any amount can be put there. Because beyond 50,000, 100 rupees. 100 rupees stamp is affixed. Then to that extent, you can fill up the check and the holder in due course can recover. But directly, when I am the drawer and you are my payee, we have a contract and there is an intention to pay a certain sum of money, that only can be filled by the holder. But a holder in due course. Okay? So you will obviously ask me, sir, who is this holder in due course? Tell me. I will tell you. It will take a little time. It's very important. That's why I put this symbol and all that. Don't worry. It's very important for you to know who is the holder and the holder in due course. Shortly we will come to that. Ambiguous instrument. Ambiguous. What is the meaning of the word ambiguous? Ambiguous means whether it's this or that. So is it a bird or is it an animal? Like that. We don't know what it is. It can be seen both as a promissory note or a bill of exchange. Where an instrument may be construed. Construed means understood. Understood either as a promissory note or a bill of exchange. The holder, there is a guy who's got it, the payee or the endorsee, may at his election, on his choice, treat it as either. For example, a bill drawn on, for example, if I am drawing a bill of exchange on myself and I am accepting it, it is a promissory note. See, there is a vagueness. Technically, it's worded as a bill of exchange. It's drawn by Srikanth on Srikanth, payable to you. You are the payee. Now, you are the holder and you can give it to subsequently somebody, everybody will become a holder. Now, you are looking at it, hey, what is this? So, technically, when Srikanth is drawing a bill on Srikanth and it is accepted by Srikanth, it is a promissory note. So, you can treat it as a promissory note and act accordingly. Okay, that is what it means. This is an ambiguous instrument. Okay. Now, this rule in section 18 is a common rule. In fact, I'm sure it's there in the General Clauses Act also. If the amount undertaken or ordered to be paid is stated differently in figures and in words. Figure means number, numerical number. Whereas word is words. For example, 100 rupees. That is words. 1 followed by 2 zeros is figures. 100. Okay. Where there is a discrepancy, where there is a difference between the figure and the words should be taken. The amount stated in words shall be the amount undertaken. For example, Mr. A, while preparing a bill of promissory note, has written, I hereby promise to pay you 10,000. In number, he has put 10,000. Okay. In words, he has put 1,000 only. Obviously, while writing the figure, he put 1 zero extra. But in words, the amount stated is 1,000. So that should be the amount undertaken or ordered to be paid. The understanding is, when somebody is writing a number, there may be mistakes. But when somebody is putting something in words, normally they won't make a mistake. Which is why, whenever you are drafting a legal document, take it as a rule from now on in your life, whenever you are drafting a legal document or any legally binding piece of paper, any figure that you are putting there, put it in words also. I know it sounds silly, it's irritating, but you have to do it. Because this rule is a general rule. For Negotiable Instruments Act, Section 18 mentions it, but generally also you'll find it in the General Clauses Act, where where there's where both figures and words are given, there is a difference, then the amount stated in words shall be the amount undertaken. Again, these are meant to protect you. These concepts are meant to protect you. Okay, so suppose you are tired, somebody comes, write a check, you write a check. While writing the figure, you write it wrongly, but writing the amount, okay, then okay. Now, have you ever thought about it? When I'm giving an online instruction for a NEFT, etc., I don't put anything in words. It's all in numbers, only figures. Very dangerous. So when I'm writing a check, I put both in words and figures. But when I'm giving an instruction to my banker online, when I'm operating my HSBC account online, I go to my online on my mobile and I put it. Be very, very careful. Very, very careful. That is why they also ask you. They don't immediately transfer the money. They ask you to confirm it. Okay? They ask you to confirm it. Look at it again fully. See that other you can edit again. When you're doing a NEFT or when you're doing a RTGS or whatever online transfer, even as most of you will be regularly using GPay, etc. Be careful. Okay? I'll tell you what happened. I was driving towards another place near Chennai. I was out of Chennai when I had to fill petrol or in my car, so diesel, and so my driver said, "Sir, give me your card." So this fellow put the card, and when they were swiping the card, they have to type out the amount, right? The amount was 4,978 rupees 6 paisa. Now what that fantastic petrol fellow did? 4,000 without the decimal point, 4,97,068. Luckily, my limit on that card is 5 lakhs. And it was already utilized, so the money was not there, so it got rejected. Suppose that in the other card I have 8 lakhs. In that card, it would have been honored. Imagine. So you have to be very, very careful. It would have been cleared. That's all, because I'm entitled now. Which is why, banks put in a lot of checks and balances. I have a feeling that if I had put 497 and I had a balance, even then the bank would not have cleared it without a call or without confirming it with me. I don't know. Normally they don't have to. Think why I'm making this elaborate point, on credit cards and online banking is, friends, though there is no physical written instrument, the transaction when you go online and instruct your banker to pay for that moment is a bill of exchange. But it happens quickly. See, you don't have the whole process of a life cycle of a bill of exchange. You draw, it goes to the drawee. Drawee doesn't simply accept it. The drawee straight away pays. So the time interval between the bill of exchange being drawn on the drawee and the drawee accepting and the paying is hardly 1 minute or 2 minutes. Even then, the legal relationship between you and him is that of a drawer and drawee. Are you able to understand? So it's nothing but a check. The legal relationship is the same, except that you're using electronic mode of payment. That's all. Okay, which is good because we want quick payments to happen. We want quick settlements and all that. It's better, right? Now here you have a diagram, my dear friends, which is very, very interesting, and I humbly request that you will remember it, because in the exam, suppose you are having a complicated question or interesting question with a lot of names in it on negotiable instrument, my suggestion, immediately make this template on a rough paper and then fill up the names there. You will suddenly find the rule is clear. As we go into this topic, I will actually be giving you some examples and illustration. I will use this diagram. Basically, the template looks like this. It's the drawer and the drawee. There are two people there, the drawer and the drawee. I call it the life cycle of a bill of exchange. Life cycle. I'm sure you studied the life cycle of a butterfly or of a mosquito when you studied biology in 8th or 9th standard. Now we are going to talk about, because the bill of exchange also has a life and a life cycle. See, the bill of exchange comes into existence, when the drawer draws a bill of exchange. The bill of paper. But it truly gets its validity only when the drawee accepts it. So drawer draws a bill of exchange, the drawee accepts it. So there is something called presentment for acceptance. Okay, presentment is not there in your syllabus, but for the purpose of understanding, I have to use the word presentment. Those sections relating to the rules of presentment are not there. Don't waste your time. Even if you're using an older version of the BOS material, humble request, don't study, because recently, I'm sure you're aware, just go to the website of the Board of Studies has a wonderful, shall we say, portal where they give you resources. Fantastic. In fact, my dear friends, I want to at this stage record my appreciation of the current Board of Studies and the way they are doing, the chairman and the great people who are running the Board of Studies. I tell you, when I was a student in 1985, this was not there. It's okay. We used to get materials that were outdated. I'm not complaining. I'm saying that's how it was. Today, it's not like that. The Institute and the Board of Studies are taking extraordinary effort to update the material. And not only that, you don't have to waste your money and time going and buying and keeping books. You just have to download it, which means one of the most important investments that you might want to look at as a student is go for a reasonably priced tab. Because you may not be able to do it on a laptop, and you may not have a laptop. Even if you don't have a laptop, I think you need to have a tablet, okay, with a good reading app, okay, that's all, and a notebook. So you don't have to print it out. Don't waste paper. Just download it, go through it on a tab, and if you want to take notes, use a paper, use a notebook. Okay. For revision, I find it for example, I read a subject, then as I'm reading it, I take notes. For example, I'll read a topic, then understand what the topic is, the essence of the topic, and create notes, which is exactly what I've done for you in this PowerPoint. Nothing new here, nothing original. Everything is there. What I've done is I've summarized it in notes, concepts, sequencing, so it's easier to remember and reproduce or recall. That's all. This is the secret of preparing for theory papers, right? But notes are very good. You can't see, just by reading from the book, you won't remember. You read, write, recall. This is my secret. I've been using it regularly. When I read, write, recall. If I just simply read, mugging up. That's called mugging up. Mugging up works, but then if you write it, conceptually, you're better off. So some people while I'm here, I'll quickly dwell on these 2 points also. Some people ask me on the WhatsApp and all, sir, I'm preparing for the exam. Can I only rely on your notes? See, not really. Read the Board of Studies material once thoroughly. Then once you got the notes, my notes is enough. More than enough for you. I still suggest go through the material once thoroughly. Okay, it's a different strategy. I might have told you this about the funnel theory and all that, where don't read everything. Go to the practice manual, okay, and see what practice manual. We didn't have that. You got practice manual. Go to the practice manual topic-wise for each topic and see which topic is covered maximum. Which topic has been regularly tested in the exam. Okay, now those topics need to be studied first. Suppose there's a vague topic that they're not even bothering to test you on, you wouldn't want to mug up. It may be the first, but then be careful. How many times is it tested? Only those concepts are important. So read that first. Read the important ones first, then go for everything. So what I normally do is I scan through the material completely once, understand the overall subject, then I go through practice manual, or scanner is also there for your information. Scanner. In those days, we used to prepare scanner. Means you will take up 10 sessions of suggested answers, and then we will analyze subject-wise the questions and see where the maximum impact has been there. I'm letting you not on a secret because scanner is there. That means the secret is out. In 1985-86, it was a select group of people like Srikanth and, Mr. Venkatakrishnan, chartered accountant, son of N. Srinivasan, partner, Fraser and Ross. We were the guys who sort of did it. So a select group of people, and we cleared, possibly with rank and all that. But the point here is, today it's available to everybody because scanner is there. Everybody can use it. We prepared our own scanners. Can you imagine that? We prepared it. Okay, and we used it. That we had the key. But I used to see pathetically people won't bother. They will read the entire material, then they will not be able to clear. When after there are people who wrote the exam one session before me, along with me, 2 sessions after me, they clear. Why? Because they don't know the approach, right? Okay. Another question that keep on asking, should I remember section number? Should I remember? No need. But concept is very important. Okay. If you are able to remember section number, bonus. You get a half mark more. But concept is more important. Conceptually, if you are clear, section numbers are not relevant. If you don't remember a section number, no problem. See, the old law used to know all the section numbers here. Today, I don't know. For example, if you ask me, no, buyback, what is the section? I may not know. The old law, I will tell you, 77A. But new law, I don't know here. Okay? New law, I don't remember. But then I know what is a buyback, what are the provisions of buyback. Right? I suppose it's 68 or something. I really don't know is the point. I don't know. Nothing wrong in saying I don't know. No shame in saying I don't know. But shame in not knowing. Shame in not. If I don't know, the next thing I'll do is to know. Okay? Again, section numbers I don't think are so important that you should mug up. But if it comes naturally, see, when it will come naturally, you read it and you keep familiarizing, it will come naturally. Okay? Especially when you write notes, it will come naturally. You will see the sequence of sections. Once the sequence is known, you know which section what. That links will start, your brain will start making those connections, synaptic connections, so that you will remember. That's how you remember here. Brain makes synaptic connections, and those connections help you to recall. If the synaptic connections are not there, you forget. Okay. So, of course, having said this, so this is the life cycle of a bill of exchange. There's a drawer, he draws the bill, that is, he writes out an instrument saying, instructing the drawee, ordering the drawee, directing the drawee to pay a certain sum of money only to or to the order of a certain person, the payee, or to his order. Bearer bill of exchange not possible, though the definition says or to the bearer of the instrument. Still, bearer bill of exchange, bearer promissory note not possible in India. Okay, I already told you that. So drawee, payee, drawer. Then the payee gets the piece of paper. Now it has no life. He has to present it to the drawee for acceptance. Then the drawee accepts it. Means on the face of the instrument, he signs. That's all. It's accepted. Even if he writes accepted, good. If he doesn't write also, sign. Then it becomes now the life has come for that piece of paper. That piece of paper can now move. Okay? So the payee can take it and endorse it. We'll see that a little bit later. It's called negotiation, endorsing. He endorses it and he gives it to endorsee 1. Now endorsee 1 is a holder. Now able to understand? Payee is a holder. Payee is a holder. He is also an endorser. He endorses it to endorsee 1. And endorsee 1 is a holder. Now when he endorses it to endorsee 2 becomes a holder. All of them are holders. Whether they are holder in due course is a different story. But all of these people are holders, right? Now a holder, any holder can present the bill or negotiable instrument or bill of exchange to the drawee. Now the drawee gets a new name. Once he accepts it, he becomes acceptor. Are you able to see the difference? When the bill is only drawn on him, he is a drawee. Once he signs and says accepted, he becomes acceptor. An acceptor has to make the payment. So he is like a principal debtor. The drawer is a surety. Any of these people, the payee, endorsee 1, endorsee 2, they are all principal creditor. So the relationship between these 3 people is a contract of guarantee. Surety. The drawer is a surety. The drawee is the principal debtor. And all these people are principal creditors. Now, only difference, in the normal contract of guarantee, the principal creditor cannot do anything without the consent of the principal debtor, knowledge and consent. Here, there is no need. There is only exception. Once endorsee 1 gets the bill of exchange from payee, he don't have to talk to payee at all. He can simply endorse it and transfer. He doesn't have to get the consent of the payee. Simply he can turn the instrument around, put his sign on it, write endorsee 2, sign, give it. Now the instrument is payable to the endorsee 2. Okay? Then endorsee 2 or whoever it is presents it to the drawee. This way what happens now? for say let us say the bill of exchange for 1 lakh rupees, they are getting multiplier, right? Drawer and drawee, there's a basic transaction for 1 lakh. He gets it. Now payee owes money to the endorsee 1. He gives it. He is cleared of his debt. The endorsee 1 gives it to endorsee 2. Cleared. So much of the liquidity is created by negotiable instruments, right? Please remember this format. Later on, when we are discussing some issues in this class, it will be very useful. Okay, so as I told you, once a person has accepted, he becomes an acceptor. That's all. Okay. How does he do it? He signs it either on the face of the bill or on the reverse side. Suppose it is not in a single bill, but a bill in sets. That is for different bills. The whole thing forming a set, everyone he has to sign. Okay. And upon one of such parts and delivered. So that he is acceptor. Right. Suppose there is a 10 bills in a bill of sets on a single document. See, I owe you 1 lakh. Instead of drawing a single paper, I draw 10 papers of 10,000 each. You sign on one and you give it back to me. All are accepted. Okay. So given notice of signing to the holder. Right. Whatever, ideally, on the bill he has to sign it, it will be better. Okay. Now we come to a concept called acceptor for honor. Now think about it. Okay, go back to my example of guy in Ahmedabad or Surat going to Muscat and all that. So our friend goes to Muscat, Oman, and he presents the bill to the Shah there. Now that Shah unfortunately has got a financial problem. He is not able to accept it. See, while he is traveling on the ship now, it's only a piece of paper. It's drawn on him. He's only a drawee. The guy in Ahmedabad said, he drew the bill. Now that bill is that is drawn on a Muscat cassette. No problem. Our man goes there, merchant goes there, he presents it for acceptance. But the Muscat cassette, he is not in a position to accept it. Whatever reason, he is embarrassed. No problem, because that instrument, if it is not accepted, then the trust in the entire community is affected. Thereafter, any bill drawn on anybody in that group will not be respected. So, any other person, for example, in the marketplace, Mandi mein, there will be somebody else. You say, hey, 1 second, bring that bill to me. I am accepting it. Take it. Are you able to understand how it works? It's a trust case. There is no relationship between the original Ahmedabad drawer and the new guy. But why is he doing it? You have to understand it. You have to understand from the context. He is doing it because the instrument should be protected. Friends, today we are talking about Bitcoin and all. Yesterday I was attending a meeting in a Rotary Club where a gentleman was talking about Bitcoins and blah blah techies and all that. Bottom line, if trust is lost, it's lost. So that way, bill of exchange is a money. Actually, it's a money, type of money. It's not currency, it's a type of money. We call it second tier money. Okay? We are creating it. But it all works on the promise, yeah. Suppose the accepting is not there, then nobody will trust a piece of paper, right? So why do you buy a Bitcoin? You honestly believe that one day you will be able to exchange it for dollars or for dollar, obviously. Okay, that's why you buy a Bitcoin, right? If you have even a single iota of doubt that the Bitcoin cannot be exchanged for dollar, Bitcoin gone. Okay, think about it. Okay, if you are not able to convert it, which is why the people don't understand the secret. Why dollar is a fiat currency? Dollar is a currency. Bitcoin is not a currency. Okay, but it's an instrument. It's a contract whereby which I don't know seriously who promises to who. Seriously, I don't know. Nobody is able to answer this question. Bitcoins are issued by who? Does that guy give a guarantee? I already told you, the currency notes that you are all having is a promissory note. The Reserve Bank of India governor has given a promise, and I trust the RBI, not the governor, and the RBI I trust, which is represented by the governor. I trust the Reserve Bank of India. I trust it. The trust is not there. The promissory note has no value, It will be piece of paper. For example, you go to say a country like El Salvador. They've adopted Bitcoin as a currency. Imagine, shame on the country where their own currency is not having respect. Their own central bank has no respect that these donkeys have to accept a foreign currency like US dollar. I've been to Cambodia. See, throughout my travel in Cambodia, I never saw one See, I'm not a numismatist, but when I go abroad, I collect some of these currencies. Cambodian currency, I don't have. Okay, but I got a lot of currency. I got Vietnamese currency. I've got, of course, Malaysian ringgit. I've got. But what I'm saying is, Cambodia, no, I really don't know how the currency looks, because throughout my visit, I was able to make payments in dollars. They accept dollar. That's a shame on these countries where their currency is so weak that they are unable. Their currency is no. Why? Classic example is our Indonesia, where they are still the rupiah. Indonesian rupee is definitely accepted by Indonesia. I mean, they make a big show about it. You only rupiah will accept and all that. But you know what? See, when I went to Indonesia, first thing I did, normally when I go to a country, I take $100 bill and I exchange it for the local currency. So I gave the $100 bill to the guy who thinks, and he looked at me, because $100 in exchange, it comes into what? At that time I remember, it's 4.5 lakhs. 4.5 lakhs, $100. 4.5 lakh rupiah, not rupees, rupiah. So they said, sir, I can't exchange, I don't have the Indian currency. So then I said, I don't have $10. Luckily, I had my agent had told me, sir, don't take $100, take some smaller currencies also. So luckily, I had a $10 bill. I gave a $10 bill and I got 4,000 or 40,000 for imagine, okay, huge inflation there, okay. And so my brother-in-law and I had a dinner in Indonesia where we paid. You know what was the bill? I remember 1 lakh or 2 lakh rupees bill. In India, it would have been about 2,000 rupees. Can you imagine the exchange rate? Check out. So, like, Indonesia makes a big show of not accepting dollar and all, but I think they will go there finally. So, what I'm trying to say is, the whole point I'm making with this elaborate example, my dear friends, is trust. A currency works on trust. If there is no trust, so bill of exchange also works on trust. The drawee cannot be trusted, then this is not the piece of paper is worth nothing. Suppose the drawee is an untrustworthy person, a pauper, this piece of paper cannot be moved. Nobody will accept it as valid payment. So that's why the acceptor for honor comes in and he says, hey, that word should not come for these documents. So this fellow is not able to accept it, no problem, he is embarrassed. I will accept it. Any person accepts it for honor. Honor means to protect the name of the person, okay, of the drawer or of the investor. So really, who is affected here? The drawer, not the drawee. More than that, the drawer, because drawee may not even see. Drawee can say, "Hey, I don't want to accept it." Even without having any financial difficulty, he can say, "I will not accept it." Then who is in shame now? The drawer. So the acceptor for honor says, "Hey, I know that Seth in Ahmedabad. I know that guy. I bring it to me. I will." So in Muscat, somebody signs it. He becomes acceptor for honor. Subsequently, he may even pay. It becomes a payment for honor. But remember, once he pays, this fellow, the acceptor for honor, will go directly into the drawer and say, hey, you pay me, I pay. And it will be settled. The point is, it's the honor of the drawer. Now, for example, take another example. Drawer draws, it's not accepted. Pay endorser goes to Muscat. And even without presenting it for acceptance, the guy endorses it to somebody because the local guy knows this guy. Hey, okay, it's drawn on him. But then the endorser one presents it for acceptance, not accepted. So that case also is there. So either way, when a bill of exchange has been dishonored by non-acceptance and any person accepts it for honor of the drawer, such person is called acceptor for honor. The payment which he makes is known as payment for honor. Person desiring to accept for honor, on that bill he will declare that he accepts under protest the protested bill for the honor of the drawer. The idea is, see, there is no direct contract or relationship between the acceptor for honor and the drawer. That's why he says under protest, only for the honor of the drawer or endorser, whom he has to name. So, accepted under protest for honor of so-and-so, or accepted under protest on behalf of so-and-so. So that tomorrow, if he makes the payment, he can claim it from the original drawer. The holder must consent to the acceptance for honor because the holder cannot be compelled. The holder should also accept. The bill must have been noted or protested, not important, but then it should be, a notary public should confirm that this was not accepted and this fellow is coming as an acceptor for honor. The acceptance or honor can be made by a person who is not already liable on the bill. Okay. See, drawee of the bill becomes a stranger. He may therefore accept the bill for honor of any party that. Think about it. Crazy. The bill is drawn on him. He doesn't accept it. Subsequently, it gets endorsed. Endorsee presents it. Now, the unaccepted bill gets. Now, the drawee who originally said, I won't accept it, now becomes an acceptor for honor. Crazy. Okay, but welcome to the world of law. Are you able to understand? When originally the bill was presented, he didn't accept it. Subsequently, it was endorsed. He accepts it. Because by not accepting it, he becomes a stranger. Now he can become an acceptor for honor of the drawer. Got it? He becomes an acceptor for honor of the drawer or the endorser. Okay. It must be made by writing on the bill. On the bill. It must be the whole amount due on the bill. Partly acceptance or honor is not possible. And the person whose honor it is done should be already liable on the bill. Either he should be an original drawer or an endorser. And it should be done before the bill is overdue. Okay? Means an outside bill cannot be accepted for honor because there is no acceptance of an outside bill. Outside means once I give it to you, you have to pay. There is no question. After sight, 30 days, 60 days after sight. Once I present it for acceptance, after that 60 days, right? So that bill can become overdue on the 60th day. So this acceptance should be made before it becomes overdue. Okay. Again, when a payment for honor is made, it must be declared before a notary public that he is paying on behalf of somebody else. Okay. The idea is to give evidence. Suppose tomorrow the acceptor for honor is suing the drawer or an endorser. He should have some proof, right? That is what is done when a notary public signs it. Now, those of you who don't know who is a notary public, it's a lawyer, an advocate who is appointed by the court, okay, as a public official. Anything, any document, legal document, it will be signed by the notary public. It's called notarizing. The advantage of notarizing is that it becomes acceptable as an evidence in a court of law. Beyond that, you don't have to prove things, especially the signature. Once the notary public signs it, the signature cannot be questioned. Which is why, whenever I enter into any agreement, for myself or for my clients, I always advise, if it's a total stranger, even stranger, why even one brother, better get it notarized. Because tomorrow he'll stand up in court and shamelessly say, it's not my signature. I didn't sign it. So better that you get a notary public to notarize it or attest it. It's called attestation. So that on the document, the notary public will put his seal and say, signed in my presence. That's all. The notary public is only content, nothing to do with that fellow, whatever it may be. But he is saying this document, and he will also keep a record of the document with a unique number. He has to maintain a register. So that way, tomorrow if I'm suing on that contract, the contract is not raised, then I don't have to prove it from first principle. It becomes a conclusive evidence that it was signed by the other party. Similarly, when the notary public, there's a declaration, affidavit, and the notary public signs it, then certain facts are clear. The acceptor for honor accepts it. He has accepted it for honor, and the drawer is due, and the payment has been made. These are no need to prove it. Beyond that, no need to prove it with other documentary evidence. This is enough. Okay. So in a court of law, this becomes very, very important there, because when you stand in front of a court and you say some statement, friends, you and I can talk anything we want. You don't have to prove it. I don't have to prove it. But when you stand up in a court of law and argue, every statement that you make should be supported by documentary evidence. You can't simply make a statement and go in a court of law. Okay, proof should be there. Either you should ideally give documentary evidence, or you should give some corroborative evidence, something. So that's another Macaulay law of Evidence Act, which is we got ideally is a documentary evidence or oral evidence, somebody who saw it coming and giving a witness statement, or circumstantial evidence, which is most dangerous. Okay. So A was murdered. At the time when he was murdered, B was seen leaving the building, but nobody saw B kill A. But circumstantial evidence is that B could have killed A. Very dangerous. But if there is nothing else, sometimes courts are willing to accept it. Okay. Now, so an acceptor for honor is bound to all the subsequent parties. Think about it. Once this fellow becomes the acceptor for honor for endorsee 1, he is not only liable to endorsee 1, he is liable to endorsee 2, endorsee 3, endorsee 4. Every subsequent party he is liable. Okay? And the party he accepts to pay the amount, and all prior parties are liable to compensate. So once he makes the payment, he can sue the endorser, the drawer, everybody. Okay. Now we come to the important topic, which is very important: holder and holder in due course. I think by now you already know who is a holder. Anybody in the cycle, you know the drawer, right from the first payee to the last endorsee, all are holders. The holder of a promissory note is any person entitled in his own name to the possession thereof and receive or recover the amount due. Now, one of the presumptions of bills of exchange or promissory note is, one of the presumptions of negotiable instrument is, the holder is a holder in due course, that he is entitled to the possession. If you want to say that he is not a holder or a holder in due course, you should prove it. Who? The person refusing to pay should do it. The man, the reason is, this piece of paper has a lot of respect in society and in trade. Now you can't simply question it. So once it is presented, pay. If you're saying he's not entitled, you prove. He may not prove that he's not entitled. All he has to show is he is a bearer or a endorser. That's all. His name is mentioned, sign. Okay. So one way you can do that is, of course, to say that forgery. You can say that the signature of the drawer or the endorser is forged. So prove it. But that's only one of the few things. Okay. Now, the holder should be a person entitled in his own name to the possession of the instrument. So he must be the bearer of the instrument, or he must be an order. He must be one of the endorsees or the payee. Payee, endorsee, bearer. Now, we use the word bearer because when Mansfield wrote the law, there was no prohibition on bearer instruments. There was no prohibition at that time. Only when our RBI came, we said no. Bearer, bill of exchange, bearer, promissory note, not possible. That is an RBI regulation. It's not in the negotiable instrument. So you will find the word bearer is also coming here. So three people can be there. A bearer can be the holder because the bill is payable to bearer, no name is mentioned. All you need to show is you are in possession of the instrument. A payee whose name is mentioned. Endorsee whose name is mentioned. Okay. These are all holders. And he must be entitled to receive or recover them. Now, who is a holder in due course? Be careful. Holder is simply a person entitled in his own name. Whereas holder in due course, very, very important. Who for consideration became the possessor of a promissory note. So consideration has to be proved. So if you're saying he's not a holder in due course, you have to prove that consideration was not given. Okay. The payee or endorsee thereof, if payable to order. Okay. So anybody who obtained it for consideration becomes a possessor of a negotiable instrument payable to bearer or the payee or the endorsee before the amount mentioned it became payable. And so any endorsement to be valid should be done before the due date. Okay. Once it is accepted, 30 days, 60 days, within that 30 days, 60 days only can. On the 60th day, 30th day, it has become payable. Thereafter, endorsement is not possible. Collection is possible. You have to go and present it any time. It's overdue. But endorsement is not possible. Okay. Without sufficient cause to believe that any defect existed in the title. So basically, holder in due course gets he gets possession of the instrument for consideration without cause to believe that there is any defect. For example, I'm sorry, I'm going back again and again. Drawer, okay, draws the bill, payee, no problem, payee gets it, payee, no, story here. Payee keeps it in a safe. Payee is clerk, a fraud. What he does, he forges his employer's signature and endorses it. Now payee's signature is forged. The endorsee one is getting it. Is he a holder or a holder in due course? Yes, definitely he is a holder because his name is mentioned on the instrument, he is entitled. But he is not a holder in due course. Why? Because he is party to that fraud here. He knew that this fellow forged and his name is mentioned with a forged signature. So he has sufficient cause to believe that there is a defect. Now think about it. Suppose he endorses it to the endorsee 2. Who gets it for consideration without any knowledge of the defect? Then endorsee 2 becomes holder in due course. Whereas the endorsee is only a holder. Endorsee is only holder, right? This diagram is very interesting. I suggest that you remember it. Okay. So he should be the holder. A holder in due course is definitely a holder. The instrument, either he should be the bearer or his name should be mentioned as a payee or as an endorsee. Okay. He should have become before the amount became due, and he should have paid valuable consideration, and very, very important, he should not have any knowledge of, he should have sufficient cause to believe that any defect. He should not have any. So he should be innocent third party. Only then you can call him a holder in due course. Right. Hope this is clear. Now the holder in due course has certain privileges. Now let's see if you have. Let's see if you have any doubts. Who's asking this? Tanu. If drawer is surety, if payee fails to pay, how will? Kana, you got a problem, Tanuji. Payee will not pay, payee will only receive it. Drawee has to pay. Once the amount is drawn, so drawee is the principal debtor. Payee is the principal creditor. Why will he pay? He will receive. Right? Got it? So drawer is a surety. See, basically drawer is a surety because the bill of exchange is drawn and accepted. Suppose the drawee does not pay, then the drawer will have to pay. Is that the question you are asking? Yeah. I will change your question. If drawer is surety means if drawee fails to pay, then drawer will pay. That is correct. Okay. Absolutely. Possessor of the instrument, whoever it is in this chain, ultimately on the it's like a game. Finally, who's holding it will take it and present it for payment to the drawee. Bearer not possible in India. So the endorsee 2's name should be mentioned on the instrument on the reverse side, wherein it should be very clearly stated and endorsed. We'll be seeing negotiation very shortly. Okay. So Ms. Tanu or Tanuji, can you please confirm that? Yeah, thank you, madam. Okay. I have been distinguishing between holder and due course like mad. If you're still not understood, please go through my lecture again on video. Holder is anybody who has possession. Anybody whose name is mentioned as an endorsee. Holder in due course, two things. He should have got it for consideration without cause to believe that any defect existed in the title. Right? See, I don't know if you, in those days when you studied Sale of Goods Act and thing, bailment you have studied, na? Sale by bailee, okay? Sale by non-owner. Okay, that's what it's a negotiable. It's Sale of Goods Act. Sale by non-owner. When you're selling, when a non-owner sells it now, it's very, very important because the person getting it should get it without any awareness about the defect in the title of the seller. Only then he is entitled. Otherwise, he has to return it back. It's very, very important. No knowledge. There's no need to get confused, sir. I will tell you. Holder is any person who is holding the instrument. His name is mentioned as a payee or as an endorsee. Now, he need not be a holder in due course. What is the distinguishing point of a holder in due course? Two things. He is not only an endorsee or a payee, he has obtained it for consideration. He has given some genuine consideration, and he is not aware of any defect in the title. So 95% of the time, holder and holder in due course will be same. 95% of the time. But there is a possibility where, I gave an example now, the payee's name is mentioned, but some stranger forges the payee signature and endorses it to endorsee 1. Then what happens? Endorsee 1 is a holder, but he's not a holder in due course. Why? Because he didn't pay consideration. Moreover, he is aware of the defect in title because he is not entitled to it because he's not paid consideration, right? It was forged and given. And possibly what would have happened is it would have been endorsed to him, then they would have collected the money from the acceptor, and the idea is to share it. To share. So they find another bakra and they go to this bakra and tell him, hey, what, this is a promissory note, it is accepted by so-and-so state. I'm sorry, bill of exchange accepted. Fantastic. Now, I need money urgently, give me 10 lakhs. You go and present it to him, he'll pay. So endorsee 2, without knowledge of defecting title, for good consideration, obtains the bill of exchange. Now, he is a holder in due course. Whereas endorsee 1 is only a holder. He's not a holder in due course. So, holder in due course is a holder. But 2 more points extra. He paid consideration and he. So, when endorsee 2 presents it to drawee cannot say, this is the privilege of the holder in due course. Drawee cannot say, hey, I think this bill of exchange is forged. Yeah. It may be forged. But to endorsee 2, no comment, you pay. Because endorsee 2 got it, he's a holder in due course. Are you able to understand now the power of holder in due course? You can. Then thereafter what he can do, what remedy he has got, he has paid now. Now he can sue who? Endorsee 1, payee, dryer. All 3 of them he can sue. Because dryer is the original surety, right? Payee, name mentioned there, endorser. Payee is sued not as a payee but as an endorser. Okay? A prior party. Endorsee 1 also. Because his name is mentioned there, and he signed it, right? So he can be sued by the drawee. But the beauty is, the guy who forged it absolutely doesn't come into the story at all. His name is also not known. He can't come into this diagram. And these guys are in cahoots. They are together. So both of them would have taken the 10 lakhs and run away. Okay, you can't find them. You might sue them, but you can't find them. So finally, dryer and payee will be left holding the baby. They have to pay. So which is why rule number 1, once you become a chartered accountant, be careful, be careful, be careful. When you're dealing with money, especially on behalf of a company where you're employed, be careful, be careful, be careful. Don't be casual. Because you and I, as a chartered accountant, we are dealing with money. Don't be casual about it. If it's your own money, be careful. If it's somebody else's money, be very, very careful. I got the point. If it's your own money, be careful. If it's somebody else's money, your employer or a client, be very, very careful. Okay? My dear friend, Mr. Hariharan, your result. Okay, thank you. I mean, that's my job, yeah. I'm a teacher. If you not understood it, I have to teach you. But even there is no big difference. Holder, everybody. Holder in due course, consideration without knowledge of Allah. There's no need to get worried. But holder in due course has a lot of privileges and you should know them. For example, we already saw that now. If it's an inquired instrument, holder can claim only what is due, whereas holder in due course can claim any amount up to the stamp value. You saw that already. It's a privilege of holder in due. Now I am linking that to holder in due course. Every prior party to a negotiable instrument is liable to a holder in due course until the instrument is duly satisfied. Who are all the prior parties? Sorry, I keep on going back to this diagram. Who are all the prior parties? See, endorsee 2 presents it to the drawee for a payment. Drawee it away. Then the holder in due course is entitled to sue everybody. Whereas the holder, sirf holder, not holder in due course, he cannot sue all the prior parties because he has no right. He can only sue the guy who gave the money to him. Nobody gave, who forged it. So if it is a forgery, it's gone. A holder cannot sue. Because you are a party to it. You knew that it's a forgery and you took it, I won't pay. So both the dryer and payee can say, go to hell. But if endorsee 2 sues the payee and dryer, sorry, they cannot tell him that it's a forgery. They have to pay it. Got it? All prior parties are liable to holder in due course. Every prior party is liable to a holder in due course. Okay? Suppose the bill of exchange is drawn on a fictitious name and payable to the drawier's order. An acceptor of the bill of exchange is not relieved from liability to any holder in due course. See, Accommodation Bill. I draw the bill on a fictitious name. Okay, we'll come to that. See, I'm Srikanth. No, instead of that, I'm putting Ram Kumar and I'm drawing. You are the acceptor. You know I'm not Ram Kumar, but you accept it. Okay? Then the acceptor becomes liable to a holder in due course. Once, see, as a drawer I have signed now, in the same signature, if endorsement is made, then The acceptor cannot allege that the name was fictitious. Got it? In those days, all this was done. Today, it's too elaborate. Nobody does it. Nobody does fictitious name. But in those days, they used to do fictitious name and it was accepted. Nothing wrong. For example, I may be a big lord or somebody who, I don't want to be seen as owing money to anybody. So what I will do, I'll draw it in some other name. Chalo, but the moneylender, the Jew, knows it. That it is drawn by me, my signature, but in the fictitious name. He'll simply smile and accept it and give it because he knows that once the bill is presented and he pays it, he can come to me and take the money. And or maybe there's already an ongoing account with him. So he accepts it. Suppose later on, having accepted it, if a holder in due course presents the bill, he cannot say, hey, this is not, there's a fictitious name, no such person exists. Sorry, you accepted it now. Now you are liable to a holder in due course. That's why holder in due course is a very powerful guy. Okay? You will be seeing one more greatness of a holder in due course. Suppose an instrument is negotiated to a holder in due course, the other parties to the instrument cannot escape liability on the ground that the instrument was delivered conditionally or for a special purpose. For example, promissory note is a classic example. Please note, 46 is talking about instrument, not bill of exchange. 42 said bill of exchange, whereas here it's instrument. So promissory note is also an instrument. Now, for example, many times, when you borrow money, you will give a promissory note as a security. Now, that promissory note can be negotiated. Suppose it is negotiated, tomorrow the guy, the promisor, the guy who's making cannot say, you know what, I never gave this instrument as an obligation to pay. It was only a security for a loan and I have repaid that loan. Whatever nonsense. Sorry. It might have been delivered conditionally to the payee. But once it goes to a holder in due course, he is entitled to collect it. Thereafter, the fight is between you and the payee. You have to pay it. You are the maker, you signed it. Which is why, suppose you have given a promissory note for a loan, nothing wrong. If you are repaying that loan, religiously ensure that the promissory note is recovered and cancelled. Should be recovered and cancelled. See, here is another classic example of 42. 42 ka diagram. X is the drawer, Y is the acceptor. X is not drawing it in his name, he is drawing it in the fictitious name of Z. Z. Okay, Y accepts the bill in the name of Z. X is not signing in his name, he is signing as Z. After having got it accepted, X delivers it to M, endorsee. He endorses it. Okay, or maybe M is the payee on that instrument. Now M is not aware that this fictitious name and all. He's simply taking it. Now M is a holder and a holder in due course. So he presents it to Y. Y cannot say it is a fictitious name. He has to pay it. Okay. A holder of a negotiable instrument who derives title from the holder in due course, he becomes a holder in due course. Think about it. See. Now here, let us, for example, I'm just giving an example, all these examples. Some donkey, what it did, it forged the sign of the drawer. Okay, it forged the sign of the drawer, right? And it presented it to the drawer and the drawer also accepted it. Now, this is a holder, right? Not a holder in due course. Now this guy endorses it to endorsee one who is getting it without knowledge and for consideration. Holder in due course. Now he gives it to another guy. Again, a holder in due course. Once an instrument passes through a holder in due course, it gets cleaned. Okay? A holder in due course will clean that instrument. Thereafter, every subsequent holder becomes a holder in due course and gets the same right. An instrument passing through the hands of a holder in due course is eliminated of all defects. A holder who gets it from a holder in due course takes it free of all defects. The holder may have knowledge of the defects, but he should not be a party to them. Okay, that's the point. Knowledge, party. Once I'm a holder in due course, then nothing can happen. Okay. When a negotiable instrument has been lost, okay, or it has been fraudulently obtained. See, I am forcing you to sign a check. I'm holding a gun to your head and signing a check. Now, check is a negotiable instrument. it has been obtained by means of an offense, means coercion. By putting the gun to your forehead, I'm getting it. Now I'm a holder. Okay, I'm a holder. But suppose I endorse a check and I give it to somebody else. Okay, that person is a holder in due course. Okay, now you cannot refuse to pay the holder in due course. Okay, so when a negotiable instrument has been lost or has been obtained from any maker, acceptor, or holder by means of an offense of or fraud or for an unlawful consideration, a possessor or an endorsee who claims through the person who found or so obtained the instrument is not entitled to receive the amount from such maker, acceptor, or holder. However, a holder in due course is entitled to receive them. See, because again, what is the definition of holder in due course? When he becomes holder in due course, he obtained it for consideration without knowledge of the defect. He is not aware that it was obtained for unlawful consideration, right? It shall be presumed that the holder of a negotiable instrument is a holder in due course. Remember, this is a presumption. Any holder is a holder in due course. If you are the acceptor and you don't want to pay, you have to prove that he is not a holder in due course. Means you have to question that he had knowledge of the defect, that he didn't pay consideration. You have to prove. Okay. But invariably, that's what so many court cases are pending only for that. Now, where a suit has been filed by a holder in due course on a negotiable instrument, the maker, drawer, or acceptor shall not be permitted to deny the validity of instrument. See, the original validity cannot be questioned. You go anywhere else, but not on the validity. You cannot say, this instrument is not valid. You go. See, usually they will argue on other matters. Especially, see, basically, if A has signed a promissory note and B files a suit, only one defense A has got. He can say, this is not my signature. That's all. Beyond that, he cannot go. Because once a promissory note there, consideration cannot be good. But when you go to court, it may become a subsidiary matter that once you see I have drawn a promissory note, I've signed it, I go. You file a suit. Now I am telling you cheated me and you obtained it. Now, when I am making that allegation, I have to prove it. Because you are a holder in due course. Your presumption is that you are a holder in due course. Okay? Right. Where a suit has been filed by a holder in due course on a promissory note or bill of exchange, the maker of the note or acceptor of the bill shall not be permitted to deny the payer's capacity to endorse. Okay? Once the instrument is given, it can be endorsed. Endorsing is the right of the holder and the holder in due course. We already seen this. I don't want to waste your time. And the time now is 8:15. So I think I will also 8:10. Another 5 minutes. We will. This is only revision of what I taught. So when you're getting this material today, go through it. Quickly to go through certain classifications of instrument. Inland instrument, okay, is one which is drawn or made in India and made payable or drawn upon any person resident in India. So it is drawn in India and the drawee is an Indian person resident in India. Foreign instrument, it is the bill drawn outside India on a person resident in or outside India. So the bill is drawn outside India, but it may be paid. It's payable by a person who is in India or outside India. Okay, bill drawn outside India or a person residing outside India and payable in India. Think about it. The bill is drawn outside India, payable by a person outside India on a person residing outside India, and it's payable abroad. What right have I got in this? Yeah, it's not, Indian government has nothing to do with this, right? But suppose the bill is drawn outside India on a person residing outside India, but it's payable in India, then it becomes payable. Somewhere that link should be there. The drawee should be in India. Okay? Or the drawer should be in India. And made payable in or drawn upon any person resident in India. So, either it should be drawn in India, or the drawee should be in India, or the drawer should be in India. One condition should be satisfied to become a foreign instrument. Both are Indians, payable in India, inland instrument. Foreign instruments are very much there. For example, when you are in export or import, this happens regularly. Letter of credit basically has an underlying bill of exchange. Okay. Foreign bill of exchange. checks are always payable on demand. Okay, you can't make a check payable at sight, after sight and all. But a bill or a promissory note will be normally payable on demand. If nothing is mentioned, presumption it is on demand. But it is maybe expressed as payable on demand or at sight or presentment. So 3 words are there: on demand, at sight or presentment. That means what? I show it to you on sight, you have to pay. It's on demand. Whereas time instruments are there. And a time instrument which is payable after a fixed period or after sight. For example, a promissory note may be payable 2 months from the date of the instrument. That's all. Promissory note cannot be after sight alone, because where is the present date? But a bill of exchange can be payable after sight. That means when I'm drawing the bill of exchange, I can say it's an order, right? Directing the drawing. Pay to Mr. X. 30 days after sight, a sum of rupees 50,000. That means what? The bill should be presented first for acceptance. That is sight. From that date, within 30 days or 60 days, the amount has to be paid. The due date will be 30 days after, 60 days after. Okay? Or you can even make it payable on a specified date. You can say, pay, even a promissory note can be made payable. I promise to pay Mr. X a sum of rupees 50,000 on 31/12/2022. So, it's payable on 2020. It's a time instrument. It's not demand. You can't present it before 31/12. On 31/12, you present it, of course, you will be seeing the grace. Or on the happening of an event which is certain to happen, be careful. It should be very certain. For example, 31/12 is certain. Like that, it should be very certain. You can't give an uncertain event. Then it is not a negotiable instrument. One of the, are you able to understand? At sight or on presentment means demand. Okay. After sight means time. You are all very familiar with this. I don't know to waste my time on this. You told me the answer. When it's made payable on demand at sight or on presentment, it is payable 3rd day after the day on which it is expressed to be payable. Suppose a bill of exchange is presented and it is payable on demand. The guy to whom it is presented has 3 days. It's payable on the 3rd day. So suppose it's an on demand and it's presented today. I'm having 3 days to pay it. The grace days are given. Again, you see, this is the beauty of our system, that the merchants in those days were kind. They said, look here, you can't go present it and say you go at evening at 5 p.m. and you present the bill at the mandi in his shop and you say, hey, pay. How will he pay? I may not have the money. He'll say, Baba, I can't pay today. So you have 3 days to collect the money and give it to you. That time is given now. You can't say, pay me now, like that you can't show. 3rd day, yes, he has to pay. Okay. While calculating the date, okay, if it's payable at a certain number of days after the date or after sight or after a certain event, the day of the date or presentment for acceptance or sight, okay, shall be excluded. Means very, very important. Suppose I'm presenting it on 14th to you, then 14th is not counted. 14th of February, I present it. 14th is not included. 15, 16, 17. 17 I have to pay you. It's not 14, 15, 16. It's 15, 16, 17. I am presenting on 14. Again, it's logical. Now see, Mansfield and in those days, the states in Gujarat had a lot of brain here. Suppose a guy comes in the evening at 6 p.m. before I'm just shutting the shop. That fellow is coming and presenting it. Say, come on, tomorrow, 1, 2, 3. Come on, that day I'll pay. Okay? So this is the logic. I mean, that way, most of the older laws, not the Companies Act 2000, that other Ganda Act. These fellows in MCA have spoiled it. They don't know English. They don't have any understanding of law, logic, nothing. Simply they will draft it, and because they are in power, they got the right to do any nonsense, they will pass a law. No, but these are not laws like that. Laws written by Macaulay and Mansfield were written by erudite intellectuals who knew what they were talking about and who knew the current scenario and what was going on in the marketplace. I told you now, Mansfield, before he finalized the Negotiable Instruments Act, he spent easily 1 year traveling all over the Gulf, the Arabian Sea, Bombay, Surat, Malabar Coast, Kochi, Trivandrum. Everywhere he went and spoke to merchants. and he asked them, what are you doing? And he documented it. And using that knowledge only, that said also he went all the way, Muscat, okay, various places, Siala, everywhere he went, and he asked people, Qatar, Doha, he asked them, what are you doing? What are you doing? And these merchants gave him information which became the law. Okay, very powerful. Right? So, when the day on which a promissory note or bill of exchange is a public holiday, the instrument shall be deemed to be due on the next preceding business day, which means one before that. This is a popular MCQ question. Be careful, be careful, be careful. They ask this as an MCQ question. See, it's there in your MCQ booklet also. It shall be due on the next preceding day. Preceding means coming before. Okay. Suppose the date of maturity is a public holiday. Okay. Then say I have made it payable on, let us say, 31st of March 2022. Now 31st of March 2022 is holiday. Then it becomes due on 30th of March, on the next preceding day. Okay. Now, my dear friends, it's high time you had a break. So let's have a break. Let me see if any more questions are there. No. Okay. Hariharan was the last question. After that, I have not had any doubts. Time now is 8:20. Okay. So 8:30, we will come back again for more knowledge on negotiable instruments. And thank you. 8:30 sharp. Don't go away. Be back. Start. Okay. So welcome back from your, I hope, well-deserved break. And let's see if there are any more questions. I don't see any more questions. I don't know. See, okay. So, see, I'm not saying Negotiable Instrument Act is a simple topic. Having a slight counter, but once you know the principles now, it's not a big deal. And my humble request is this diagram that I draw, sort of make it a template. So whenever you get a problem in the exam or any question which involves, this fellow endorses that fellow, this fellow, simply put it in the diagram. Automatically you will get the logic. And remember the rules. One of the important rules is the privileges of the holder in due course. Please remember that. Privileges of the holder in due course. Very important, principle wise. And so now we are going into possibly the core, the essence of the Negotiable Instruments Act, because the Act itself says Negotiable Instruments Act, right? Negotiable Instruments Act means negotiation. So negotiation is the essence of the law. Now, just give me 1 minute. I'm taking the questions. Yeah. What is negotiation? Yeah. Absolutely, Pooja. It's not difficult, but it's not simple, but different. Yeah, different. One more thing, this law is very old law. So you have to really live. That's why, I'm giving you example of Mansfield, Surat ka Seth, and Ahmedabad Seth and Oman, because that is how it works. Today with international business and online, some of these principles only will apply. You can't use every word, don't try to get a meaning, why, what, and all. Just ignore it. But even now, we have negotiable instruments. Promissory note is very much, if you want to borrow money from a bank, first thing they will make you sign is a promissory note. Okay? Like that. For example, if you want to borrow money from me, the first thing I'll take from you is a promissory note. Okay? Which is my very important documentary evidence in a court tomorrow. Okay? Bill of exchange is there, but bill of exchange, what has happened? It has become totally, it's not what it was in those days. See, for your information, when you were studying in +2, you would have studied journal entries for bills of exchange. Journal entry in the books of the dryer, journal in the books of the dry. There you would have studied 2 types of bills, trade bill and accommodation bill. Here you never find the word now. In this act, nowhere Mansfield has defined a trade bill, accommodation, because in those days there was no difference between a trade bill and an accommodation bill. What is an accommodation bill? What is an accommodation bill? Do you remember accommodation bill? That is, see, there are A is drawing a bill on B. I'm just going, A is drawing a bill on B. B will draw a bill on similar amount on A. So both these 2 bills will be exchanged. That is, A draws on B, B accepts, B draws on A accepts. Now what happens? A will take his bill to his banker and negotiate. Means he will endorse it to the banker and the banker will collect it from the B. B will take it to his banker and negotiate so that he will endorse it to his bank and the bank will wait and collect it from A. This is called accommodation bill. Finally, when both of them mutually pay, it's gone. This is like financing. In a way, they are using bank finance, right? In a way, who is the person? Both these banks are lending money on the security of a bill of exchange, right? Today, you can't do that. The Reserve Bank of India has very clearly prohibited accommodation bill. That is why you don't find accommodation bill today. The only trade bill possible means if a bank has to negotiate a bill, first thing they will ask you is invoice and delivery challan. First thing, got an invoice, delivery challan, supply over, proof of supply is there. Now, show me the bill. So trade bill is only possible. Accommodation bill prohibited. It's called kiting because people are misusing this accommodation bill and cheating the bank. This was an old story, 90s ka story, 98, 99 ka story, where many big companies, they did kiting. That is, A will draw a check on B, A will send a check to B, B will send a check to A. But check was also negotiable. Now, check is also a negotiable instrument, right? So the check will be discounted by the bank. What is the meaning of discounting? I got a check from A. Means what? A has directed his banker to pay. Right? A has directed his banker to pay. And that check is with me now. I take it to my bank. In my bank, that bank account, okay. Immediately they will give me the amount of that check. 90% they will give to me as the funding. But very short term, not for long, very short term, say 15 days, 30 days. Now 30 days later, they will present the check. When the check is presented, it actually, check discounting, it can't be more than 48 hours. Means I got a check, I have presented it to you. Clearing will take 48 hours. Now that 48 hours, I don't have to wait. They will immediately give me the money. 48 hours, within 48 hours, the check will be presented payment. But many people misuse this facility, where bankers also, they misused it. I'm not talking about now, I'm talking about those days. For you, those days. For me, the time when I was actively starting my practice and all, 97, 98, okay, 90, 91, I was Pricewaterhouse till 91, 87 to 87, I qualified at the age of 21. When I was 21 years old, I became a chartered accountant. 87, 91. I was till 91 beginning, I was with Pricewaterhouse. 91 March, May, I think I resigned. Then I started my own practice since then. So the COP I've been holding from 87. Day I qualified, I got my certificate of practice. Rare, never have I worked except for Pricewaterhouse. Even then I was holding COP, but I was a qualified officer of audit officer of Pricewaterhouse, which is now PricewaterhouseCoopers. In those days it was Pricewaterhouse. So at that time, 92, 93, so 97, 98, my practice was slowly building up and was building my practice. At that time, this check kiting became a big problem. So backwardics and all, one of the instructions they will give is, especially in the LFA, long form audit report, have you seen any cases of kiting of checks, check kiting or accommodation bills? We'll say no, but if even such a possibility is there, we have to report it to the RBI so that that particular branch will be in deep shit. So point is, when Mansfield drafted this law, accommodation bills were common because trust was there. Whereas the same method was misused by people, so the RBI said, no, don't do it like that. Okay? No. In fact, your Bitcoin technically comes under Negotiable Instruments Act. Technically. But even there, I would not be able to, because in fact, yesterday that learned gentleman who was a technical man and a chartered accountant, I was asking him, boss, you're saying Bitcoin, my currency, you're saying it's a currency. I want a 500 rupee note here, which is signed by the Reserve Bank of India as a promissory note. Tomorrow I can go and claim it from the RBI. Who is making the promise in the case of a Bitcoin? Nobody is able to give an answer. Nobody on earth. You check out. Who is making the promise? Suppose tomorrow you want to take money and you go. Who will you go to? Which is why, there are a lot of these local guys who are printing their own online guide. Nonsense. And what is this credit worthiness? See, a bank which is definitely credit worthy, for example, HDFC Bank and ICAI Bank are pretty big. SBI, of course. Now, even State Bank of India cannot print a currency, I say. Think about it. If SBI goes ahead and says SBI coin, actually it will be having more credibility than your so-called, some nonsense coins, and I don't even know the names of these so-called cryptocurrencies. SBI coin is more value because tomorrow I know for sure that if I go to SBI, he'll pay. I mean, I have trust in SBI. 100%. Because got reserves, yeah. The balance sheet I can see. But these days, what is their balance sheet? Who are they? Simply, you can't make it, yeah. It's not possible. Ultimately, the whole thing, the credibility is relying on your promise. Who is making that promise in the case of a Bitcoin? Who is agreeing to pay? One thing. Two, what is he agreeing to pay? Okay, it's a currency you are saying. So Bitcoin is one of the worst scams waiting to happen. It's going to burst. Many learned people, chartered accountants, of course your technical engineers and all the techies are foolishly supporting Bitcoin. I'm shocked and surprised to note advocates and chartered accountants being a little vague on Bitcoin and talking as if it's something valuable. If you're honorable and honest chartered accountant or an advocate, or forget honorable advocates, honorable chartered accountant should not support Bitcoin because it goes against the grain of every financial principle that we learned. It is absolutely useless. One of the worst things that ever happened to the world is Bitcoin. You're going to see that It's going to happen. 2008, they got the subprime crisis now. At the time of subprime, in 2007, when all the world markets were going up, fellows like me were shouting and saying, this is false. It can't be sustained. It is not sustainable. It's not sustainable. Nobody believed. I completely sold my portfolio in 2007. But for some really beautiful blue chips, which are very, very deep discounted long-term buys, like Reliance and all, everything else I sold. Took my money and built a building in Chennai. That's it. Whereas those guys who hung on to it, waited, 2007 crash. 2008 subprime crisis crash. Everything gone. Overnight, all gone. Okay. Same thing will happen for Bitcoin. Bakras who are now holding it, thinking that it's going up. Sorry, 100%. See, one guy may win, two guys may win. They may sell and come out, they are intelligent. The guy who's holding it, finally holding the baby, he is in deep shit. Who is that person? We don't know. That person could be anybody. So let it not be you. Don't go to Bitcoin. Or if somebody is buying your father or uncle or senior, 40 plus, none of us will buy. No 40 plus guy will ever buy because we know better. We have seen more and more. We have seen so much in this world. Only young fellows will buy 22, 23 because they have not seen it yet. You have not seen the world. You really don't know what. I have seen so many. I have escaped so many crises. So when a Buddha says this, you will get angry because Buddha ho gaya. He's an old man. Don't listen to him. Correct. Don't listen to me. You learn yourself. But I never made those mistakes. I learned from somebody else's mistake. There are senior people to me, aged people, my gurus. I learned from them so that they told me, Srikanth, don't do this. From their experience, I accepted. But today, no way. Buddha, don't listen to that donkey. What does he know about technology? I'm a Sisa. What does he know about technology? This fellow is all ignorant fellow. Don't listen to him. Buy Bitcoin. But don't. Sorry, this is a lecture on negotiable instrument, but I'm saying Bitcoin is dangerous. Don't go there. And let this become a proof that 2 years later or whenever, when Bitcoin collapses, let this be a proof that Srikanth said don't buy. Okay? That's the point. Good. Moving on. What is negotiation? Negotiation is transfer. A piece of paper becomes negotiable. Classic example is a currency note now. When you give a 500 rupee note to somebody, remember, what are you doing? You are negotiating, Papa. Why? Because what is that currency note? Look at it. It's a promissory note. Who is promising? RBI, governor. I promise to pay the bearer a sum of rupees 500. So you are the holder of a bearer instrument. So how is it transferred? How is it negotiated? By delivery. Means, I give that 500 rupee note to you, physical possession transferred, ownership transferred. You are now entitled. That is how currencies work. If you really go into monetary theory, that is how currencies work. That's why I made this unnecessarily elaborate comment about Bitcoin and showed that it is not a currency. Because there is no promise. Who is making the promise? See, when a sovereign is making a promise, it's a currency. When there is no sovereign, there is no government or similar authority making a promise, sorry, it's not a currency. It's only a contractual obligation, like any other bill of exchange, where A draws on B, B accepts. It's like that. So the whole thing works only on the creditworthiness of B. If B is creditworthy, good. Otherwise, not. So we should make such inquiries and find out before we buy. Right? And believe me, even the smallest inquiry will show that none of these donkeys is financially sound, and that they cannot honor their promise. Okay. Good, but then, they are hiding behind technology and who all technical terms and all. Mr. Srikanth, you cannot understand blockchain. You cannot understand mining. And now I know everything about blockchain and mining. Blockchain and mining are totally different. They are good. I'm not against that. It's only a so-called Bitcoin that I'm saying is a danger. Even the original Bitcoin, as understood by Satoshi Nakamoto, was a good idea. But crazy, but not bad. The problem is what's happening now. Okay, and every donkey which's got a website can print a Bitcoin. There's no control. Who's controlling it? What's happening? Which government is controlling? Which government can get? That's why all governments are not knowing what to do. And the internet has created a virtual world where it's shall we say, geography specific, non-government specific. Very dangerous. I think this is something, we've been talking about since 2005. I conducted a lecture at a B school on IS audit and IS security. At that time itself, we were arguing, who is controlling the internet? What are the laws that govern? And the only conclusion is there is no law. Internet is lawless. That's why there's a dark web where there's no law. The dark web, see, if you go and get into a contract in a dark web, you can't go and file a suit in a court, yeah. Okay. You can't do anything. You simply have to keep your mouth shut and go. It's all working. It's an honor among thieves. That's how it is. Anyway, good. So, where an instrument is payable to bearer, as in the case of a currency note, near delivery, simply deliver. Okay? Delivery may be actual or constructive. Now, you guys should know what is actual delivery and constructive delivery. When I give the car to you personally, physically, you take possession, it's actual. When I give the key, it's a constructive, symbolic delivery, right? Or deemed delivery. More importantly, when the promissory note is given to your agent, endorsement given to your agent, it is constructive. Okay, so like that. So if I make a payment to an agent, it is constructive. I have not given to you, but I given to your agent, deemed constructive delivery. Okay, where instrument is payable to order, actually agent you can even say it's actual delivery because agent is you, key facet per se, facet per alium, but still, since it's not directly given to you, it's constructive. So in the case of an instrument payable to order, there is a need for endorsement and delivery. Means what? The instrument should be turned and on the back you should write the name of the endorsee and sign. Now 58 we already saw, right? Where an instrument is obtained by unlawful means or by unlawful consideration, it is not acceptable. Forgery is a nullity in law. Only exception, we saw it in 58, only exception, holder in due course. A holder in due course is protected and he protects subsequent parties. But anybody who has knowledge of that fraud cannot claim. Who has not given good consideration cannot claim. Otherwise, okay, a negotiable instrument is freely negotiable, bearer instrument by delivery and order instrument by endorsement and delivery. Okay, delivery is very important. Physical possession is very important. We already saw this. I'm not going to get constructive delivery. We saw where it's delivered to the agent or clerk or servant. Okay, whatever. It's a constructive delivery. Not to you directly, but to your agent. Right. When on the instrument, he signs the same, either on the face of the instrument or on the back. Okay, or on a slip of paper. That slip of paper, see, for example, sometimes what will happen, a bill of exchange may be endorsed many times. So 7 endorsements. After the 7th endorsement, there is no place on the back of the instrument. Then you can attach a paper, which is called an allonge. And on that paper you can endorse. That's called an allonge in French. You'll find a lot of French terms here because the commercial language in Europe was not English, it was French. The commercial language in Europe was French. Okay, only the Britishers used English. But then slowly they became so big that English became very popular. But the commercial language after Latin was French. In fact, to a great extent, French is the mother of English. Because many words in English have been derived from French and Latin, right? Many words. But then English became the dominant language. So the French become but French is the original language. English is not an original language. English is a derived language. Okay? As I told you, Germanic origin, there were Germanic, Scandinavian and Norse was there. You had the French, you had the Latin, of course. And then Latinized French was spoken. And then the English became very strong. And then they said, we won't speak this. And we changed that. So the Germanic words also got in and it became what we now call English. Okay, I mean, it's a recorded fact. If you're an Englishman and you're getting angry with me, please don't, because it's a fact. Okay. Now, the maker or holder is endorsing it and is called the endorser. Please note, the endorsement of a negotiable instrument followed by delivery transfers to the endorsee the property therein with the right of further negotiation. Right? Straight away, if once it's coming to you, you are entitled to further endorse it. I can't prevent you. Whoever is the final endorsee presents it, takes the payment. If the payment is not made, that final endorsee, being a holder in due course, can sue everybody in the chain. Everybody in the chain. Right? Where the endorser only signs his name, it's called in blank. Doesn't put the name. It's a blank. It's blank, right? Blank endorsements are possible. But when I mention the name, it's called in full. Endorsement in full. Sometimes we do blank because you might say, sir, give me the bill of exchange, just endorse it to me. I will not take the payment, I may give it to somebody else, I will put the name, don't worry. No problem, I'll give it because as far as I am concerned, my date is over once I sign and give it to you, right? But you can put somebody else's name also and do it. An endorsement is restrictive, very important, restrictive. When the endorser, while making endorsement, restricts or excludes the right of the endorsee to further transfer the instrument. Normally, a negotiable instrument can be endorsed, no clause. But at the time of endorsement, if the person puts a restriction, then it cannot be endorsed. Okay? He cannot transfer it, he cannot further endorse it. It's called restrictive endorsement. Examples. On the screen on your left hand side, you see restrictive endorsement. These are all on the left hand side, these are all restrictive endorsements. Pay the contents to C only means what? Nobody else can claim. Pay C for my use means C is your agent. He can't endorse it further. Pay C or order for the account of B. So C is B's agent. So C cannot endorse it further. B can, because B is the original principal, but C cannot. C is an agent. Without the permission of the principal, he cannot do it. But technically, it's restrictive. The idea is, I am paying you. I don't want this guy doing any fraud, so I'm clearly putting pay C because C is going to receive the payment, but not for himself, as an agent of B. Okay. The within must be credited to C. It's like an account pay crossing. Do you understand? When I am the payee, I endorse it on the reverse. I can put an account payee endorsement. Even an endorsee can put a cross. Account payee crossing can be done, which means it will be credited only to the account of the persons whose name is mentioned as payee or endorsed. Now, when you simply say pay C, it's a classic endorsement. Pay C, sign, endorsement. Further endorsement possible. There is no restriction on further negotiation. Pay C value in account with the Oriental Bank. No restriction. Okay? Except that we are saying pay it only to Oriental Bank. That's all we are saying here. But C can further endorse it. Okay? You're only saying the money has to go from the Oriental Bank. That's all. Pay the contents to C, being part of the consideration in a certain deed of assignment executed by C to the endorser and others. No problem. All you're making is you're giving a clarity about the consideration. That's all. But C can endorse it further. Because see, this line only proves that C got the instrument for a valuable consideration. That proves that he is a holder in due course. Now C can endorse. There's no restriction. Right? But the minute you put pay the contents to C only, you might ask me, sir, how is it important for me? I'll tell you. Remember all these things. They might mix and match and say which among the following is not a restrictive endorsement. So they will give 3 restrictive endorsements and 1 say pay C. So you should remember which is not a restrictive endorsement, which is a restrictive endorsement. Classic multiple choice question. Be very careful. Students are asking me, sir, give me some inputs on multiple choice. I'm giving you so much inputs on multiple choice. Every question, you can create your own multiple choice questions. Okay? I'll tell you one thing. Multiple choice questions are not something special. They are only for the convenience of the examiners, not for the convenience of the student. But a smart student, if he knows the law correctly now, for him multiple choice or any type of question he will answer. What is that? Instead of asking me to write, you're asking me, you give me a better advantage. But a person who doesn't know the friends, by mugging up 200 multiple choice questions, you cannot become an expert. There may be one more question which is not in this 200. But by the instrument, I cannot make it conditional. I will pay the money if the harvest I promise to pay so and so 50,000 if the harvest is good. Sorry, that's not a promise. But that negotiator can put a condition. Okay. Very, very important. Sans recours. The pronunciation is sans recours. It's a French word. Sans means without. Recours means recourse. Actual English word. Recourse. That is, recourse means going to me. Suppose there is any problem, come to me. That's a recourse. But it's recourse. But in French, it is sans recours. Okay. So when at the time of endorsement, see, bill is payable to X. Now X is endorsing it to A. So he is writing, pay A or order without recourse to me. Means what? Suppose it goes to A endorses it, goes to B is the holder in due course now. Whatever it is, B cannot sue X. Why? Because X has endorsed it, sa reku, without recourse to me. Okay, don't come to me. It is at your own risk. Pay A or order at his own risk. So once A gets the sa reku and he further endorses it, subsequent parties get it sa reku. None of them can go to X. Baba, they can go to the drawer. Absolutely, they can sue the drawee acceptor. They can sue the drawer, but not X. Whoever made the sa reku endorsement is out of the loop. More about it when we come to circuitry in action, right? Where an endorser by express words abandons some rights or increases his liability, then it is facultative. For example, normally, if later on we'll see this, if there is a dishonor, there should be a notice of dishonor. You should go to the Notary Public and get it noted, which is not in your syllabus. But once you say notice of dishonor waived, then in a way you are increasing your liability. You're saying no need for notice of dishonor. If it is dishonored, I will pay. If it is dishonored by him, bring it to me, I will pay. So pay A or order, notice of dishonor waived is a facultative endorsement, where I am agreeing to something which is not necessary. I am going beyond. Why I will do it? Why I will do sa reku? Why you will accept a sa reku endorsement? Because you have no other option. I will tell him, boss, you want payment now, I will give you. Here's a bill of exchange, take it. Endorse sa reku, okay for you. Anything happens, don't come to me. If you are in such a bad need of money, you will accept it. Or if the drawee is a powerful person who will pay, you have no doubt you will accept it. Because after all, I am not going to pay now, only he is going to pay. And he is a strong individual financially. Chalo. So then you will accept a sa reku also. Why I am doing it? I want to protect myself. That's it. Our story over. Shall I give you? Negotiations are going on. Finally, you are accepting some, instead of not taking even anything from me, you are getting something from me. Na? In those cases only, sa reku will be done. Otherwise, sa reku endorsements will not be. The guy accepting is a fool or what? Sa reku. But if he have no other go, he will accept it. So remember, all these things are commercial necessities. Without understanding the commercial background, simply you cannot bug up this one. So, a real life situation, where I have supplied goods, fellow is not paying, I go to him, I catch him by the collar, he says, I will pay you, but I will give only a negotiable instrument. Okay, chalo, I already, A owes money to me, the other party owes money to me, here's the bill of exchange accepted by him, will you take it? I take it, endorse it. But when I endorse him, sa reku, it's okay, yeah, give it to me, because at least something is coming out of this deal, nothing, without getting nothing. Only then sa reku. Similarly, facultative, where you very badly want to get something from me and you don't have money, then you are saying, Baba, I'll give a bill of exchange drawn on such and such a person. In case he doesn't pay, notice of dishonor waived. Okay? No problem. Somewhat better. See, it depends on who is having a greater need in a negotiation. So accordingly, and that's what, Mansfield, again and again repeat, Mansfield did not write the law. He described what was already going on and made it into a law. Okay. Where the endorser does not want the endorsee to incur any expenses. Like, for example, once a dishonor is there, will be a notary charges, etc., etc. Now, sa frame means he's saying whatever may be the expenses, I will bear it. The endorser says, in case there is a dishonor and you are spending money on my account. So, sa frame means no expenses are on my account and you don't have to bear it. So the endorsee gets it free of expenses. So any expense incurred by the endorsee at the time of dishonor or etc. be borne by the endorser. Right? Suppose there is a negotiable instrument. It has been endorsed in blank. Okay? So the person holder of that in blank now endorses it in full. The amount of it cannot be claimed for the endorser in full except by the person to whom it has been endorsed in full or by one who derives title through such person. Little complicated, huh? If you see the diagram, you will understand it. See, X is the drawer, Y is the acceptor, accepts the bill, so no problem. Now the bill is live, it comes to A, who is the payee. Now what A does, A endorses it in blank. He turns the instrument, signs, doesn't put any name, gives it to B. So B gets it endorsement in blank. Now B is the endorser now. He is endorsing it to C. Now there B writes the name of C. A has already signed now. Above the signature of A, B, who is the holder but not named in the instrument as an endorsee, he writes C. Now C becomes the endorsee. That endorsee, again this idiot what he's doing, without signing, without making payment, saying D, pay D and all, he gives it to D. Now D is the bearer or possessor of a bill of exchange. His name is not mentioned as an endorsee there. Whose name is mentioned? C's name is mentioned. Okay, now, finally, Y dishonors. Okay, that's why. If Y pays, absolutely no problem here. The bill of exchange comes to an end. We'll see discharge and it's discharged. The instrument is discharged. Story over. But suppose Y fails to pay, then D, on whom he can file. D as the bearer is entitled to receive payment or to sue drawer, acceptor, or A, who endorsed the bill in blank. But he cannot sue B or C. Okay. Be careful. If, however, see why it happened, because C did not put D's name as an endorsee there. C didn't sign it. Therefore, the amount of it cannot be claimed from the endorser in full, except by the person to whom it has been endorsed in full or by one who derives title. So, technically, C can sue B, but D cannot sue C or B. But if, however, C, instead of passing the bill to D, passes it by regular endorsement. See, instead of simply giving it to D, he writes pay D, signs. Then D is the holder in due course. He can claim from C, B, A, drawer, acceptor. Everybody he can go and claim. Okay. Suppose we already seen 58. Okay, where it is obtained by fraud or offense, etc. A holder cannot claim who has knowledge of the defect. But a holder in due course who has received for consideration and without knowledge can claim. Okay. The holder of a negotiable instrument who has acquired it after dishonor, he is accepting it by non-acceptance or non-payment with notice. He has only rights as against the other parties, the rights therein of his transferor. See, the bill is already matured, but you have no other go, you are accepting it. Then you can only have the same rights as your transferor. In other words, where a bill of exchange is acquired after dishonor or after maturity, the person holding it is not a holder in due course. He only gets the right of the person who transferred it to him. Okay? Whereas, if it is done before maturity, then the person obtaining it is a holder in due course. That is what it means. So up to payment or satisfaction, it can be negotiated, even after the date of maturity. But once it is paid, end of story, you can't do anything more. We come to something called negotiation back, also known as circuitry in action. Let's see. Okay, thank you. Wonderful, Mr. Jamil. Thank you very much for those nice words. Yeah, token given is considered as constructive, no doubt. Hariharan is asking a very good question. Whether it will be mix of law and all. No. MCQ will be only on one law. For example, if it is a negotiable instrument, it will be only a negotiable instrument. Even a question will not be mixed here. Even case studies are not mixed. Okay? It will be only on that law or specific provision of law. They have not reached that stage, where they are willing to test you on any part of the syllabus. No, only one law. Most of MCQs are fairly simple. If you know the principles, easily you can answer multiple choice. Easy. Yeah. If you're finding this a little confusing, don't worry. The lecture is only the first time you are being introduced to the topic, right? And I'm doing my best to make it simple, slow, blow. But still, because of language, maybe because the way I speak English is a little confusing to you, no problem. Read the subject, read the PowerPoint again once more. And if possible, watch the video again. Many times, students ask me to explain again and again in this class. Time is just running out, and this is the last class. So you can watch the video again. Again, you watch the holder in due course. I have not understood. You say, if you are saying it, go back. That part alone you watch. Fast forward it, watch holder in due course alone. What I am saying. You understand? And then read the material, read the notes. Suddenly you will understand. Okay, the knowledge will come to you. Okay. Now negotiation back means, see this diagram, you will understand. If I explain it, you won't understand. Diagram will explain. See what happened, A draw, B accepted. C is the payee. Now C negotiates it to D normal, proper endorsement. Pay D, signed C. Pay E, signed D. Pay F, signed E. Pay C, signed F. Now what happened? C is the payee, original endorser. He also becomes endorsee. Now are you able to see the circulation here? Circular, that's why it's called circular. It's called negotiation back or circuitry in action. The same person, a prior party, becomes a subsequent endorsee. One of the prior parties becomes an endorsee. Okay. Then what happens? There's something called circuitry in action. How to understand it? Suppose now what happened? C gave it to D, E, F, then F again gives it to C. So C is again in possession as an endorsee. Now C has two roles here. C as the payee, C as the payee endorser, one role, endorsee. So what happened at this point in time now? As an endorsee, he further endorses it. X, who is the holder in due course. Now the law says X can definitely go to B. Suppose B does not pay, X will sue C and A. Now C, what it will say, simply go to F. Then what F will say, go to E. Then what D will say, E will say, go to D. What D will say, go to C. And so X will go mad. So they say X cannot sue D, E, F. Once an instrument has been negotiated back, all the prior parties to it are excused. And a person who becomes the holder in due course under this negotiation back cannot make any of the intermediate endorsers liable. D, E, F are all intermediate endorsers. So X cannot sue D, E, F. Exception, if C does a sariku, see, while endorsing it to X, if C says sariku, means don't come to me, then what happens? No circuitry in action. Why? Because C will now become liable as an original endorser. Because he made a sariku. Okay? So, I'm sorry, he's made a sariku. So, he is not liable on this document. Now, then what happens? X cannot sue C now, but he can sue F, E, D, A. These fellows are all liable. But if it is a normal endorsement and X takes it and there's a circuitry in action, D, E, F are excused. But if it is a sariku, then prior parties are also liable. Intermediary parties are also liable. I hope you understood this. And the diagram will explain it. See the circulation. Think about it. Suppose B doesn't honor the bill, X can sue D. X can sue C. C will say go to D. D will say go to E. E will say go to F. F will again say go to C. It will become a circular action, circuitry in action. So the law is very sensible. It says once this happens, the loop is cut. The loop is cut. None of these fellows is liable. Go to C directly and A. Leave these fellows out. Don't waste your time suing them because simply they'll say go back, it will waste. But suppose this is sariku, then these guys are also liable. Got it? Now we are talking about discharge of the discharge means the liability is made nil. Discharge can be done by cancellation. That is, the parties together decide to cancel it. Okay? Then, when a bill is cancelled, what happens? The party and all subsequent party who have right of recourse against the party whose name is cancelled are discharged from liability to the holder. See, I am the endorser now. I have mentioned somebody cancels my name means I am no longer liable on the instrument. I am discharged. As a party, I am discharged. But the instrument is still valid for other parties. When the holder releases any party by any method other than cancellation, maybe a separate letter, etc., is attached, then by release also the party can be discharged. Of course, when the payment is made, the instrument itself will be discharged. All parties are discharged. Payment will discharge everybody. So discharge can be made by the holder, okay, allowing the drawee of a bill more than 48 hours to accept. Then what happens? There's a discharge of the drawee by the holder agreeing to qualified or limited acceptance, by the drawer not duly presenting a check, by the bill coming to the acceptor's hands after maturity, etc. Now, discharge can also happen by material alteration. Friends, combine this with your knowledge of law of indemnity. Remember, if there is any understanding between the principal debtor and principal creditor without the consent of the surety is discharged. Are you able to understand? Same concept. Who is the surety here? Drawer. If there is a material alteration in the negotiable instrument, then such material alteration enters the same void as against anyone who is a party thereto at the time of making. Once a material alteration is made, the original drawer, every endorser before that date is out. The guy who gets it, only his right is against the endorser. That's all. Okay. What is the material alteration? The original instrument is either destroyed, okay, that is defaced, or then the parties who are agreed to be liable on the original instrument can't be made liable, yeah, because what I signed was not this. You keep making some changes in it, you scratch out this and that, make material alteration. I didn't sign this instrument. What I signed, you show I will pay. This is an altered instrument, I'm not going to pay. So there's an automatic discharge by material alteration. Anything that alters the business effect of the instrument, date, amount, name, anything, making it speak differently or adding some words which are not intended, automatic material. Now, I'm not going to, since time is running out, I'm not going to go through every example of material alteration. All this is given in the instrument material only. Please read it. Because, again, a multiple choice question. Which of the following is the material alteration? Because there are many things that are not material alterations. These are all permitted alterations. So what they will do is, they'll give some examples, out of which one of them will be a permitted material alteration. Or 3 will be permitted, 1 will be not permitted. Then they will say, which of the following is not a material alteration? Okay. For example, signing an instrument in blank is not an alteration. Once an instrument is signed in blank, okay, and I fill up the name or the amount, it is not a material alteration. I give a blank check to you, you put your name later or put somebody's name, it is not a material alteration. Where an incomplete instrument, inchoate instrument is filled up by the holder, not a material alteration. It enables the holder of an instrument endorsed in blank to convert it into endorsement in full. That is not a material alteration. See, like in our example now, A endorsed it to B without mentioning any name. Right? So B gets it, his name is not mentioned. Only A has signed it. Now B puts C's name there and makes it in full. By writing above the endorser's signature a direction to pay to any other person as endorsed. This is a valid alteration. The holder of an uncrossed check may cross it. Valid alteration. The alteration should be apparent on the face of the instrument. Some other writing, some other agreement between them, letter correspondence, no. On the instrument, there should be an alteration. Okay. These are all. So 3 permitted alterations we have seen, 20, 49, 125. Other than that, any other material alteration is a will discharge. Okay. These are not material alterations. These are permitted alterations. Where the holder of a negotiable instrument without the consent of the endorser destroys or impairs the endorser's remedy against a prior party, the endorser is discharged from liability to the holder as if it has been paid at maturity. Example, it's given in this is not an example given in the material. This is an example given in the act, which is given in the material. Okay. All the examples given in the material are all from the original act, including contract. Everything is original act illustration have been given without even changing names like I have done. A is the holder of a bill of exchange made payable to the order of B, okay, which contains the following endorsements in blank. So first endorsement B. So B, pay B, A. Then Peter Williams. I'm sorry, pay B somebody. Then B endorses it to Peter Williams. Then Peter Williams endorses it to Right and Go. Finally, it comes to John Rosario through A. Okay. Now, sorry, John Rosario. Then John Rosario, who is the holder, fourth endorsee, endorses it to A. John Rosario endorses it to A. Now, this fellow A, what he does, he cancels the name of Peter Williams and Right and Go. Without John Rosario's consent, okay, he strikes out Peter Williams and Right and Go. What is he done? He is the holder. Without the consent of the endorser, he destroys or impairs the endorser's remedy, because by cancelling Peter Williams and Right, what he does? Suppose the acceptor of the bill does not pay, A we can sue John Rosario, no problem. Now, because this fellow A has struck out Peter Williams and Right and Co., A cannot, John Rosario cannot sue Right and Co. and Peter Williams, because their names have been struck out. So, at that point in time, Mansfield protects this guy and says the endorser is discharged. Now, suppose the acceptor of the bill does not honor, then A can sue. Who can he sue? He can sue the dryer, whoever it is. He can sue B. Obviously, by his own idiocy, he cannot sue Peter Williams and Right and Co. because he has cancelled their name. Now, Section 40 says he cannot sue John Rosario also. Because you changed it. You struck it out without my consent. Okay? Thereby impairing my right. So A is not entitled to recover anything from John Rosario. Again, remember, because he has struck out Peter Williams and Right and Go, this idiot cannot go there also. So the only place he can go is B, dryer, B. That's all. Because anyway, the acceptor has rejected. He has not paid. So you can go to B and dryer. That's all. All these fellows are discharged in a way. Because Peter Williams and Right and Go are not legally discharged. But you stuck up their name, yeah, like an idiot. What can you do now? Okay. Of course, larger question. Suppose B pays to A, then he can sue Peter Williams and Right and Go. Because when he signed it, their name was very much there. Subsequent, they can go there, definitely, as subsequent industry. So, again, as I told you, once you put it in a diagram, it becomes easier. Right? Time is really running out. I'm sorry, but anyway, we are coming to the end. Discharge. As if we already saw discharge of a party, where a party who is liable on a negotiable instrument ceases. Then you have discharge of instrument. Means what? The bill of exchange itself comes to an end, right? So discharge of the instrument happens only on payment. Discharge of party, we saw many examples, including this example, where when A struck off Peter Williams and Right and Go, John Rosario got discharged by operation of Section 40. Discharge of parties. When a party who is liable ceases to be liable, discharge of party. But discharge of instrument happens only when there is a payment. So dishonor means what? Either non-acceptance or non-payment. Either non-acceptance or non-payment. When the bill is presented for acceptance, the person who is supposed to accept it, the drawee, does not accept it, dishonor. Then what happens? The drawer becomes liable. Or, suppose, for example, drawer gives it to payee endorses, subsequent endorsee goes to present it for acceptance. Every prior party is liable for non-acceptance. Please note, by non-acceptance, the instrument is not discharged. The instrument is still valid. You can sue the drawer, you can sue the endorser and all. Only on payment it will get discharged. Are you clear? Discharge of instrument, payment. Mere non-acceptance will not discharge, but it's a dishonor. And of course, it is accepted subsequently non-payment. There is also dishonor. Whenever there is a dishonor, okay, I already explained to you, when it is presented for acceptance, not accepted, dishonor by non-acceptance. When it is presented for payment, then dishonor by non-payment. Okay. Sometimes, the drawee may give a qualified acceptance. For example, qualified acceptance would be, I'm saying pay A or order a sum of rupees 5 lakhs. Now it goes to him for acceptance. He writes, accepted for 2 lakhs. That is qualified here. Qualified means what? He is not accepting for 5 lakhs, but he is accepting for 2 lakhs. So qualified, changed, subject to. He is saying, I am liable, subject to 2 lakhs, not more than that. Now, this is something that the holder has to decide whether to accept or not. The holder can either treat the instrument as dishonored, that's all. He can treat it as dishonored. So, effect of dishonored by non-acceptance is that the holder can start an action against the dryer. Okay, he can treat it as dishonored. I got a bill for 5 lakhs, presented for acceptance. He is accepting for 2 lakhs. Straight away, it's dishonored, and I can file a suit against the dryer and endorses, and need not wait for the maturity of the bill. Okay, of course, if he accepts the qualified acceptance, then he can recover only 2 lakhs. He can recover only 2 lakhs, but a holder in due course can recover the full amount. Now you understand? Holder and holder in due course. See, this guy knows that acceptance is qualified, no? But holder in due course who gets it can claim. A promissory note bill means obviously he can't claim it from the acceptor. Now, acceptor is restricted to 2 lakhs now, but the holder in due course who gets a qualified accepted bill can sue the dryer for the full amount. Whereas the guy who accepted the qualified acceptance, now the endorsee who accepted the qualified acceptance, he cannot go beyond 2 lakhs. Because you accepted 2 lakhs now. You claim 2 lakhs from him. If he does not pay, come to me, I'll pay you 2 lakhs. But a holder in due course gets it clean now. He can claim from the dryer even 5 lakhs. Correct? But acceptor will pay only 2 lakhs. Acceptor will only pay 2 lakhs because he is restricted and clearly given. He is not liable. But dryer liable for the full amount to the holder in due course. Yeah, it's not complicated. Just wrap your mind around it. Let me see what the time is. Wow, we got another 10 minutes. Give me another 10 minutes of your valuable time. We'll complete this topic. Right? We almost come to the end of. Can you see the ending? We saw the definitions of promissory note, bill of exchange. Then we saw their characteristics. Then we saw negotiation. Then we saw discharge. Now dishonor. See how logically we have moved from birth to death of this instrument, right? From birth to death. Like that, if you understand logically, it's easy to understand. Okay, friends, I am not a brilliant person. Okay, when something is taught to me for the first time, sometimes I may not be able to understand it. No problem. All of us are not brilliant. Like a few of us are brilliant. They will, the minute you tell, they will understand. Okay. Hanumanji, he learned all the Vedic knowledge from Surya Bhagavan. You know how? When Suryan was moving around according to those days, it's bullshit, but I believe Hanumanji used to go along with him in front of him and learn. See, that type of students are rare, na? But just when the guru is telling in his job, he will learn, the student will learn. I don't think we are students like that. So what Hanumanji did not do was come back and do revision and studying again. But you and I have to do. You have to read the topic again once. Possibly, luckily for us, technology gives you the video. This donkey is available on video. You can listen to this donkey again and again, try to understand. If it's suddenly you will get it. Okay? Unless you are a student like Hanumanji, immediately you understood it, I'm very happy. Okay? That is my luck that I've got great students like you. The minute I tell you I understood, wow. A promissory note, bill of exchange or check is to be dishonored by non-payment when the maker makes default in payment. Okay? Suppose presentment is excused. That's why presentment is not in your syllabus, don't bother. Where a promissory note was sent by registered post and the party liable refused to receive the post, the bill was held to be dishonored because the fellow knows that there is a bill of exchange in it. Okay, so he is not accepting it. It amounts to dishonor. Okay. This principle was laid down in this case, Venkata Subbaiah versus P.R. Rao. Now, we have come almost to the end of the topic. Let me see if you have any more, because now we are going to dishonor of check, the last 138 section, because I thought Tanuji's, it's complicated. Yeah. By a car loan, finance company gives the car loan to Mr. X, surety Mr. Y. Hey, you are going to surety, this is negotiable instrument, you are asking question in anonymity. Anyway, let us see. If Mr. X not paid and abscond, Mr. Y is liable to the extent of only a return of car or also. See, if this fellow has signed he would have signed a promissory note. See, that is when surety is Mr. Y would have signed a promissory note, right? Whatever is the amount stated in the promissory note, only he is liable. The return of car, no. What the finance company will do, obviously a car cannot be recovered, they will give a police complaint and that will be going on. In the meantime, you are asking a pure indemnity guarantee question. This is a contract of guarantee. The lender is the principal creditor, the borrower X is the principal debtor, and our friend Y is the surety. Never be a surety is the principal. Now, X has absconded with the car. Okay, luckily not with Y's wife. Okay, only the car. Whatever it is, the finance company will file a suit against X as the original borrower and Y as the surety to the extent of the amount stated in the promissory note. If no promissory note is there, only a letter of guarantee is there, and no amount is mentioned, then the entire loan with interest can be collected from Y. Whatever amount due to from X will be collected from Y. That is, instead of X, no, Y will pay. Now be careful. Suppose the car is subsequently recovered. Y can file a suit as the surety, he can file a suit against X and recover. And if the car is recovered, some money is recovered by the finance company, that money should be paid to Y because he settled in full now. So whatever recovery was made by you should pay to him. Got it? And so only a return of car or also give loss incurred, yes, interest, any expenses, that depends on the contract, Baba. If the contract is silent, only the amount of the loan, whatever was guaranteed. But if the contract also says interest expenses, then interest. If you say, I promise to stand guarantee for X and pay whatever money owed by him to you, then gone, everything. Suppose you say, I stand surety for Mr. A and in case he does not pay, I am liable for 5 lakhs, then 5 lakhs. So it all depends on what the contract says. Okay, good question, incidentally, but connected with this because once a promissory note is given by a guarantor, he is bound on that. Irrespective, he cannot say, I only gave it as a guarantor, blah, blah. You are liable. Okay. That's why my humble suggestion to you in future, never become a guarantor. Never become a guarantor for anybody. Whenever I conduct negotiable instruments classes, and indemnity guarantee classes, I always tell my students, as a future member of our institute, see, why get into all this trouble? Never be a guarantor for anybody. So being a surety or guarantee is dangerous. Never do it unless that is your business. If you're a banker, do it. If you're a very rich person and you know that, even then be careful. Because don't take on the liability of somebody else. My humble suggestion to you. Okay. It's my humble suggestion. Don't worry. Okay. If you still want to sign. Tomorrow that person will run away, you have to pay. Okay. At least be 200% sure of that person before you sign the guarantee. Okay. Only a paper guarantee you give. Till date, by the grace of God, I have never given a guarantee for anybody. And nobody has given a guarantee for me also. If you want a guarantee, I will say, don't lend me the money. If you don't trust me, don't lend me the money. Or else take my building as surety, take water as surety. I will give the security, take it. Based on that you give. If somebody has to promise you about me, don't give the money to me. If you're, I should be so trustworthy that I should not need a surety. Like that, I have been living my life. So, and I have not signed surety also for other people. Wonderful. Now, here is the case of check dishonor. With this, we will close the topic. Kindly give me, I know you're all hungry, etc., etc. 9:30, 10 minutes. Give me 10 minutes, we'll close this. Very easy. Dishonor of check. The check is drawn by a person on an account maintained by the banker. That check is dishonored. Okay? Means what? What is dishonor? The check is presented to the bank and the bank is returning the check as unpaid. Please note, the quality should be, the check should be for payment of an amount of money to another person for the discharge in whole or in part of any debt or other liability. Very, very important. So, which is why if you are filing a suit under 138 for recovery on a check dishonor, you should establish that there was a commercial transaction. For example, you supplied goods or rendered a service. He gave a check. You, the other party. Because as far as you are concerned, you got a check. It's signed by him. Dishonored. It's a summary action. You are entitled. But He can then say, hey, no, I didn't give the check with intention that it will be presented. It's a security. You prove it, Baba. You show some communication from me or have a witness, something. That case will drag on and on. Beautiful. It will feed an advocate for at least 5 years. It will feed him. It's a beautiful case for my son, incidentally, if he is an advocate. Wonderfully, he can enjoy. Okay? Because the case will keep on dragging. Witness said, Vaida, go on and on. Beautiful. Welcome to the world of law. Okay? I mean, while you are studying all this now, it's all seeming very simple on these pages of the book, right? The reality in the court of law is totally different. My guru was a practicing advocate and he taught me as if I'm also going to practice as a lawyer. Though I was only going to be an ordinary chartered accountant, he taught me as if I'm going to practice as an advocate. And he used to teach me how the court will happen, what will happen. It was not so straightforward. 138 law summary proceeding. That will take 6 months, 9 months for coming for hearing. Okay? Delayed justice is always there. Denied justice. Welcome to the world of the courts. Not only in India, everywhere in the world, except America possibly, where the judicial process is faster. All other parts, including Europe, courts work slowly. Okay? Don't think you can take it tomorrow. But then, as a chartered accountant, you should know, because 138 references will come to you as an auditor. Because auditor or as a CFO, you should know 138. Suppose your company has sold goods, other company has given a check is dishonored, then you can take action under 138. Right? So you should know. The check is returned by the bank because the amount is not sufficient or it exceeds the amount. Okay? See, while returning the check, the banker will give a reason for return. There it should say insufficient funds, etc. In case it's an OD account, exceeds balance or exceeds arrangement, whatever. In all these cases, it is dishonor. Suppose the drawer sends a letter to the banker saying, there is a problem in this matter, I don't want you to pay him, don't pay, but the money is there in the account. Please note, it is not dishonor. Okay, we'll come to that point. I'll explain again. Such person shall be deemed to have committed an offense. Please note, 138 makes it an offense. It's a criminal offense. 138 is a criminal offense. Dishonoring a check is a criminal offense. So, see, you can also file a money suit against him separately, civil suit, in addition to that 138. 138, because when a check is dishonored, the trust in checks and banks will be lost. So you cannot make that happen. Because all of us work on basis of trust. So if checks are dishonored, you are questioning the trust itself. So they say you are a criminal and you will be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to twice the amount of the check. See, point is, suppose the guy doesn't want to go to jail, he can pay 2 times the amount. Why 2 times? One will be taken by the government as penalty. One part will be paid to the guy who's filing the suit. Now, because he owes me 4 lakhs, he gave me a check for 4 lakhs, dishonored. I'm now coming to you, fine is 8 lakhs. So that government will take 4 lakhs and give me 4 lakhs. Beautiful, na? It's a good concept. 138 is a very nice section. If properly done, check should be presented within the validity period of 3 months. The demand for payment should be sent within 30 days. See, it's the time-bound procedure. Check is presented 3 months, within 3 months, dishonored, send a letter to him demanding payment. Mention, whereas I have sold you the money, whereas I have sold you the goods, you are owing me a sum of so-and-so. You are given a check number so-and-so, so-and-so. Check was dishonored, proof enclosed. Now I demand that you shall make the payment. Immediately, like the depot. The drawer should make the payment within 15 days. See, when a check is dishonored, immediately you cannot run to court. You should make a demand. And that demand should be rejected for 15 days later also is not paying. Then you go to court. Okay? Again, where a person has instructed his bank to stop payment of a post-dated check due to non-availability, then 138 is attracted. Okay? But suppose money is there in the bank account and because of certain other dispute I'm saying, hey, don't pay the check and I'm instructing the bank not to pay, the bank will return it as referred to drawer. They will not return it as insufficient funds. Even if they say refer to drawer, if on that day of presentation money was not in the bank, then it is dishonor. Suppose money is there in the bank, then refer to drawer. No. Some dispute is there, he's saying don't pay. Banker being an agent is instructed, he won't pay. Very well. But Suppose there is no money, and because there is no money, you are doing this nonsense, then 138 is attracted. How will the 3 months be computed? From the date mentioned on the check. If it's a posted check, 3 months will be counted from the date mentioned on the check. Wonderful. This is possibly my last session with you. I really enjoyed, teaching you. I gave you my mobile number and my email ID and all in good faith. But I humbly request, please ask questions. No problem. Send a WhatsApp. I will answer. Many students have already sent messages, and with my limited knowledge, I have given them replies. But one request: now, don't ask controversial question. Don't argue with me. I'm not here to argue with you and win an argument. I'm a teacher. If you think I'm wrong, please go ahead and say I'm wrong and proceed with your life. I'm not, because some students, they have raised questions that are argumentative. I'm not very happy with that because I'm a teacher. Okay, and I can explain to you. So genuinely, when you want knowledge, I will explain. I'm here to help you. But if you're even if your controversial approach is, it's not good for you in the long run. So my heart. Other than that, if you don't understand a problem or something, etc., feel free to ask me, because as a teacher, I am bound to explain. But don't misuse this privilege to enter into controversy, or don't point out error in the Board of Studies material and ask me to confirm it. Go to Board of Studies directly and inform them. I'm not here to clarify that. If you have a genuine doubt, I will clarify. Okay? I will clarify. 100% I will clarify. I know I'm not supposed to make this promise. I'm going overboard in giving this because some elements you misuse this privilege to ask me questions that are controversial and wasting my time. Stupid questions, unnecessarily. Board of Studies is like this. What I not there for that. But a lot of people are asking good questions, even out of the topics I covered. No need. One lady sent a question on share capital loan, which I never covered. I will answer. Why not? I'm here to help you to understand the subject, write the exam, clear the exam, become a chartered accountant. Goal clear enough? With that, I bless you all and I wish you all the very best, and look forward to meeting you in future as a member of the Institute of Chartered Accountants of India. All the best. Bye.